on the list serial 40
40. Counsel for the petitioner seeks permission to withdraw this petition. This permission is accorded. Petition is dismissed as before. Serial 40. Have to put a sheet.
From after there was this serial number 36, we asked for a petition which is last name by
आपको गलत लग रहा है क्या आगे हो पाएगा? करने दीजिएगा तभी होता है।
उसको एक फाइनल
नहीं प्लीज अभी कुछ
From the supplementary list, fixed case at 10:30, item 4, DA.07.04 of 2026.
कौन सी आज क्या आया था?
हाँ डेली लिस्ट में
इसको बोला गया था कि दोनों के एक साथ हैं।
हाँ काउंटर पे ये ऑर्डर करना है और दूसरा केस कहाँ पर है?
in daily liस्ट में
आज serial number
2 and
2 and 15 one
2 and 15
18
18 भी कौन
नहीं
है?
18 सॉरी हाँ 11 है 11
ऐसा कंफ्यूजन में मत रहिए। 2749 right
yes yes
and 15 2781
yes yes
correct 2781 2749 and first is
एक और है आइटम 11
this is 2704 ये आपने सप्लीमेंट्री लिस्ट
2704 supplementary item 4.
आइटम 4 ओके और बिल्कुल ये थी और चौथा कौन सा है?
नहीं मेरा आइटम 11 2704
2704 is serial number 4 of supplementary list. Item 11 तो
हाँ यस यस
ओके देखिए DA number 2704 of 2026, DA number 2781 of 2026 and DA number 2749 of 2026. All these cases arise out of same FIR. Let they be tagged. The counsel for the respondent, the opposite party is directed to file counter affidavit along with criminal antecedent report of the respective petitioners. Mr. Salin Kumar Tiwari is directed to produce the case diary of the case. बाहर से आएगा कि यहाँ से? आपके पास से आएगा?
ये एक वो गलती बोली थी आइटम आज डेली 2 में
हाँ 2
215 and supplementary
That's right. आप हमको पेज डायरी दे देंगे नेक्स्ट डेट पे 2 दिन पहले। द काउंसिल इज डायरेक्टेड टू सबमिट द केस डायरी टू द कोर्ट एटलीस्ट 2 days prior to the next date पोस्ट ऑन 29 और जो भी आपके APP होंगे कंसर्न उनको बता देंगे ठीक है। काउंटर फाइल करना है ना दे विल बी फाइलिंग।
From the supply list, ready for fresh filing, item 1, DA.06.90 of 2026.
The trial is going to be shortly concluded
Lords,
as per the interim order dated.
that is there, Lords, but I'm just on the facts, Lords. 14 points and
When the trial is at the fag end, there is no question of
Lords,
that.
may I only
I will expedite your time.
Lords, may I only request you? 2 सबमिशन केवल उससे
हम
नहीं
कंसिडर कर लेंगे आपका दोनों सबमिशन बताइए।
केवल एक देखा जाएगा पेज नंबर 27
पेज 20
अल्ट्रासाउंड रिपोर्ट
पहले FIR पढ़िए ना। FIR बिना पढ़े अल्ट्रासाउंड क्या है? FIR पढ़ी?
पेज 27 सभी निवेदन पूर्वक कहना है कि मैं
सुनाई नहीं दे रहा हूँ।
सभी निवेदन पूर्वक कहना है कि मैं
नाम मत लीजिए।
मैं अपने घर पर रहकर पढ़ाई कर रही थी, अपने ही गांव के स्वयं के पास ट्यूशन पढ़ रही थी।
द पिटिशनर राहुल कुमार।
दिनांक 3/1/25 को समय करीब 12 बजे राहुल कुमार मेरे घर ट्यूशन पढ़ाने आया और मुझे पढ़ाने का उस मेरे परिवार के लोग नहीं थे। इसका नाजायज फायदा उठाकर राहुल जेब से चाकू निकाल लिया, भय दिखाकर मेरा मुंह दबाकर मेरे साथ रिक्शा के लिए चला। नाउ मेरा सर इसी को केवल हम एक बार आई एम जस्ट ट्राइंग टू टेक नेक्स्ट पेज में Let's इसमें let's kindly see bottom portion में when the ultrasound was done, it was 32 weeks 1 day. Let's may kindly see one thing, the date on which the alleged occurrence has taken place. 3/1/25. Now my lords, the FIR lords bottom में date देखा जाएगा 31/7/2025. That is 28 weeks बाद. Even if the alleged occurrence is taken to be true, तो इतना ही मेरा submission था कि
the pregnancy is mismatched.
second my lords that I have denied now that she has a son. I have also denied during the trial that he is not my son. That test has also been not done.
You applied for a DNA test? Did you apply for a
I have
DNA
denied
test?
during the bail petition also
No,
that
did you apply for a DNA test?
but अभी तो मेरा कुछ हुआ नहीं है तो I am not aware.
You are willing for a DNA test. Should I record it that you are willing for a DNA test?
Definitely, Lord, sir. If I am making such a submission in my case also, so that definitely will be deemed to be there. Lord, sir. Only these two submissions contained.
Heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner has submitted that though there is direct allegation against the petitioner in the FIR, but
And there is no repeated
And-
action. Lord.
and the victim is pregnant, but the ultrasound report which has been annexed along with the bail application does not match exactly with the period of pregnancy when counted from the date of the alleged. Submits that this is enough to show that the petitioner has been falsely implicated in this case. The learned counsel for the state has opposed a prayer and has submitted that there is direct allegation against the petitioner. The victim has supported the case under section 1 in a statement under section 183 BNSS. And as per the improved order dated 8/1/26, out of 7 charge sheeted witnesses, 4 witnesses were already examined, and it has been recorded by the learned trial court that the trial would be shortly concluded. After hearing the learned counsel for the parties and considering the direct nature of allegation as a direct and serious nature of allegation as against the petitioner, and trial appears to be at the fag end, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the witnesses are promptly produced before the court. Counsel for the state is directed to communicate this order to the SP of the concerned district and also to the directors.
Item 2, DA 2693 of 2026.
Earlier rejected, no? The offense under section 376 and 546 of the IPC. Earlier rejected on 8/9/2025. that is in BA number 7603 of 2020. I will just only refer to the impugn order.
Council for the state is directed to file a
Only
contract.
impugn order, two things. I do not longer that there is direct evidence. But you also will just see the impugn order.
सर काउंटर एफिडेविट मंगा रहे हैं, एफएसएल रिपोर्ट मंगा रहे हैं, नहीं मंगाए मंगाए ना, क्योंकि एफएसएल के कारण आपका प्रोसीड नहीं कर रहे। सर एवरी केस आई हैव रेड, प्राइम फेसी हमको आइडिया है कि क्या करना है, आप लोग को सुन के ऑर्डर करना है, इसीलिए यही ऑर्डर कर रहे हैं। एफएसएल रिपोर्ट नहीं आ रहा है ना आपका, इसीलिए हमारा ट्रायल प्रोसीड नहीं कर रहे।
यही बोलना चाह रहा था। Sorry brother, I could not read till verses 5.
Council for the state is directed to file counter affidavit in this case. After taking instructions from FSL. And produce the FSL report before this court in sealed cover. Let the case diary be called for from the concerned court. Post on 30th April.
Item 3, DA 2695 of 2026.
Yes.
case of US cyber offense initiative earlier, the matter was withdrawn by the court bench. इसमें क्वेश्चन रेज किया गया था कि ये टाइड अप होगा आफ्टर सम आर्गुमेंट
हाँ.
the matter was
So what do you have to say? After some argument.
raised it.
No, by on with particulars. There were certain particulars which were not which were missing in the bail application. It is not on merits. Because I know that there are numerous orders which says that the particulars of the fabricar is missing and other particulars are missing. And numerous cases the bail application has.
After some argument that they treated as the tied up matter, so that means I am submitting, only submitting. That's my submission was simply after some argument that I treated as the tied up matter.
क्या बोलना है?
इसमें हम लोग आज पर जो हम लोग का प्रैक्टिकल सिंपली जो रहता है उसको टाइड अप नहीं
After some argument.
आर्गुमेंट को टाइड
DA number 2695 of 2026. Counsel for the petitioner submits that since the matter was withdrawn from coordinate bench in DA number 1264 of 2026, dated 10/3/2026, after some argument, the present case is a tied up matter. The office is directed to place this matter before the Honorable Chief Justice for listing it before the concerned court on the administrative side.
Item 5, DA 2714 of 2026.
कल इंस्ट्रक्शन लेने के लिए बोला गया आउट ऑफ 6 विटनेसेस 5 विटनेसेस लेने
Right.
चाहिए और डॉक्टर से
कभी नेक्स्ट डेट भी पता
आई
करें
टू कंप्लीट 24
24/4 प्रोड्यूस कर देंगे ना अपने विटनेस BA number 2714 of 2026. Counsel for the petitioner on instruction submit that out of 6 witnesses, 5 witnesses have already been examined. The counsel for the state submits that the next date in the trial court is on 24/4/2026, and on that day, the official witness will be produced. IU, who is the remaining witness, will appear before the court for his witness. In view of the fact that the trial is at the fag end, and considering the nature of allegation, this court is not in, and the bail application was already rejected by this court earlier in DA number 8138 of 2025. This court is not inclined to enlarge the petition on bail. That should be sufficient. Or be direction change. Counsel for the state is directed to communicate this order to the SP of the concerned district to ensure compliance.
Item 6, DA.07.04 of 2026.
May I please? The alleged offences under section 77 and 75 of the BNS Code. Corresponding is 354C and 67A of the IPA. The allegation against the petitioner is that the petitioner and the informant, they both used to work in the same company in Bangalore.
How much is the custody?
Not custody, I'm saying not 16/12/2025.
Any antecedent?
No, not no antecedent.
Where have you stated?
Paragraph 11.
Or the learned counsel appearing on behalf of the petitioner, nobody appears on behalf of the petitioner. बेल बनता है बेल बन रहा है नहीं बन रहा They were working together in Bangalore.
I just want to be in my
हाँ, 16 major है. They were working together in Bangalore.
I just want to बात नहीं करते जैसा भी आज हो डॉक्टर्स ने भी फोर्स किया बोलते हैं
बेल का एलिगेशन तो है नहीं.
हाँ है नहीं बट ये बहुत फोर्स किया और मोबाइल में
फोर्स किए तभी ना यहाँ पर हैं. चलिए बेल तो करें. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 16/12/2025 and the victim and the petitioner were working in the same company at Bangalore. And they were throughout in talking terms. He submits that the case appears to be of consensual relationship. Counsel for the state has opposed the prayer for rule and has submitted that there is direct allegation of misapprehension. After hearing the learned counsel for the parties and considering the nature of offence and the fact that the petitioner and the victim have been working together at Bangalore, the petitioner is directed to be enlarged on bail. However, the petitioner shall not disturb the victim in any manner whatsoever.
Under heading for admission, item 7, DA.11.812 of 2025.
Yes.
This case of cyber office. With all the secret information, the first information report was lost. Case 16 is the first information.
Tomorrow certain cases are listed. Yes, just a minute. आपके बहुत सारे केसेस हैं. सारे केस एक साथ टैग करके कल रखते हैं. कल केस डायरी का ऑर्डर करें. इसी FIR से. बिकॉज कोई भी उसका डिटेल्स हैं उनके पास. किसी को बेल हुआ, किसको?
You are also apprehended on the spot. 4 persons were apprehended on the spot. Allowed to be
Other two accused, they have filed the application before this honorable court, and after some argument, they have withdrawn that case. And just on part of yesterday in this case, I have seen that he have limited his fraud 6,70,000 from others. So I find affidavit if asked for as well. 6,000.
तो वो आपके सब आर्गुमेंट को विड्रॉ किया हुआ केसेस.
हाँ वो है लक्ष्य BA नंबर 10605/2025 and BA नंबर 10753/2025. That is
कहाँ का विड्रॉल ऑर्डर है?
ये
हमारे कोर्ट. किस कोर्ट का विड्रॉल ऑर्डर है?
just
एक से बताइए जरा.
just
That is the coordinated.
just
तब तो वो हमारे पास नहीं लगेगा. आपका सब आर्गुमेंट है. तो आप बहस से आपको क्या बोलेंगे? Yes, you are.
Co-accused has withdrawn after some months.
From which,
It's not petition.
from which court?
Yes. Just noted. Honorable Mr. Justice Sanjay.
The learned counsel for the state is directed to file counter affidavit in this case and also produce the case diary. केस डायरी कोर्ट से आएगा?
हाँ, कोर्ट से गया ना? I also.
कब से कस्टडी है आपका? 21.
8.
Let the case diary be called for from the concerned. Counterfile कर दीजिए and place on record the criminal antecedent report.
Yes.
Post on 29.
Okay.
30 तारीख. 30 तारीख.
30. Okay.
Item 8, BA 111852 of 2025.
So we are rejected and show on the rejection order and show on page 16. Out of 9 charge sheeted witnesses, only 1 is left.
Only one is left.
Yes. Taken instruction order annex 26.
What is the next date?
Deposition.
What is the next
date? Instruction that properly I am not being able to take.
Next date.
Next month, the exact date I am not able to
Okay.
place now.
But only one witness is left.
Yes.
BA number 11852 of 2025. The learning counsel for the petitioner submits that the bail application of the petitioner was rejected earlier in BA number 1588 of 2025 by order dated 25/2/2025. And in the meantime, all the witnesses except one have already been examined before the court. Counsel for the state has opposed a prayer for bail and has submitted that the trial is at hand and the state would ensure that the remaining witnesses produced. After hearing the learned counsel for the parties and considering the fact that the bail application was rejected earlier and the trial is in flagging, this court is not inclined to enlarge the petition on bail hence rejected. The state is directed to ensure that the remaining witnesses promptly produced before the court. You communicate to the director of prosecution and SC of the concerned district. कुछ नहीं फाइल करना. ये जो ऑर्डर है एसपी को कम्युनिकेट होगा तभी ना. कभी कभी विटनेस आते हैं एग्जामिन नहीं होते हैं. अननेसेसरी फॉर एग्जामिनेशन ऑफ फ्यू विटनेसेस द केसेस आर पेंडिंग एंड ऑन द नेक्स्ट डेट दे शुड प्रोड्यूस द विटनेस. एक ही विटनेस खाली बाकी है.
Item 9, BA 11897 of 2025.
Last week, antecedent, one antecedent of the antecedent happened and another antecedent. The DPS came back for case diary. There is no victim in this case. So, line formation.
So the answer there is victim.
So now, ये para 87 में 150 I have given a statement that they see.
Para 87 नहीं सर. केस डायरी का.
Yes.
कस्टडी कब से?
The study है जो
14/10/2025 तो सिमिलरली सिचुएटेड पे उसका कोऑर्डिनेट से भेजना
ऑर्डर दीजिए।
ऑर्डर
Heard the learned counsels of trading on behalf of the parties. The counsel for the petitioner submits that the petition is in custody since 2025 and has no criminal antecedent. He has submitted that as per his information, there is only one victim linking the petitioner. In this, the amount involved is rupees 19,998. He has also submitted that two co-accused have been enlarged on bail in BA number 11596 of 2025 and BA number 11306 of 2025. नाम के साथ डिटेल दे देंगे. Counsel for the state has opposed the prayer. However, the submissions made by the counsel for the petitioner is not in dispute. After hearing the learned counsel for the parties and considering the custody of the petitioner and bail having been granted to two co-accused, the petitioner is directed to be enlarged on bail.
इसी केस के हियरिंग के समय बोला गया था कि डायरेक्टर प्रोसिक्यूशन
I
आज नहीं आया है। एक्चुअली हर इस डिस्ट्रिक्ट का हम डाटा बता रहे हैं। कुछ डिस्ट्रिक्ट का डाटा आ जाए, कुछ का डिस्ट्रिक्ट वो वाले डाटा मेरे पास अवेलेबल है इस बार। तो कभी
आइटम 10
कुछ हमें चाहिए डिटेल्स
सारा डिटेल्स अभी वो बोले कि मॉर्निंग कोर्ट
और FSL में क्या प्रॉब्लम है? FSL का रिपोर्ट इतना दिन तक क्यों पेंडिंग है? Because if he makes a statement that because of paucity of manpower in FSL, then we will see what is to be done. क्योंकि FSL रिपोर्ट के नहीं आने के कारण ट्रायल हमारा पेंडिंग रह जाता है और जो केसेस बिना FSL के डिसाइड हो जाते हैं उसमें मिसकैरेज ऑफ जस्टिस का भी चांस है. तो बोथ वेज इट इज नॉट गुड.
एक्चुअली एफएसएल के केस में एज पर माय नॉलेज डाउन केसेस में देखते हैं जो भी आईओ जो होते हैं कोर्ट में प्रेजेंट करते हैं उस डॉक्यूमेंट या मटेरियल को कोर्ट में एग्जीबिट मार्क होता है. इसके बाद जाता है एफएसएल के बाद डायरेक्ट कोर्ट में आता है.
आखिर एफएसएल से कोर्ट क्यों नहीं आ रहा है? इसका भी तो कोई रीजन होना चाहिए ना. वी हैव टू फाइंड आउट कि एफएसएल में प्रॉब्लम क्या है, क्योंकि यहाँ पे 25 के एफआईआर में विक्टिम है, रेप विक्टिम है, इनका एफएसएल रिपोर्ट नहीं आएगा तो कन्विक्शन कैसे सिक्योर होगा, राइट? सो दैट विल बिकम अ ग्राउंड फॉर रिलीजिंग द बेनिफिट ऑफ डाउट. उसको मिलने का चांस रहता है. दूसरी बात इनजस्टिस का चांस रहता है. अगर मान लीजिए एफएसएल मैचिंग नहीं है तो फिर उसको क्लीन एक्यूटल होना चाहिए ना. बेनिफिट ऑफ डाउट क्यों मिलेगा, राइट? तो इसीलिए एफएसएल वाले प्रॉब्लम पर भी थोड़ा ध्यान देने की ज़रूरत है. और अगर वैसा होगा तो हम लोग हाईकोर्ट अपने एडमिनिस्ट्रेटिव साइड में भी लेकर चाहे किसी भी तरह से एफएसएल में मैन पावर को हम लोग को पे करना जरूरी है. जहाँ तक हमको मालूम है वहाँ मैन पावर की बहुत ज़्यादा प्रॉब्लम है. कितनी वैकेंसी है ना, ये थोड़ा सा देखना जरूरी है.
आइटम 10 BA 12088 of 2025.
Yes, please.
ये section 103(1) of BLS में and charges were submitted under section 108 BLS में. The additional member that informant about hanging with their off. There is no indication of assault, only suspicion had been made in this case.
What is the date of marriage?
Marriage का कहीं
आप कौन हैं?
हम ऐसे
How are you related to the victim?
ये 3 महीने से केवल ये लोग साथ में रह रहे थे. मैरिज का कहीं कोई नहीं आया है.
या कहाँ से बोल रहे हैं 3 महीने से साथ में रह रहे हैं?
For the FIR में आया हूँ. May I read the FIR?
Just a minute. You are already married,
हाँ.
and in the pretext of marriage, you stayed with her for 3 months.
Yes.
And when she asked for marriage, then you went to your first wife.
वो भी शादीशुदा है.
कौन? Victim is also married.
हाँ वो
कहाँ से? कहाँ से बोल रहे हैं? From where are you saying? कहाँ से बोल रहे हैं?
Daily paranoid आदमी का पुना गया उसमें सेकेंड पेज में मिडिल पोर्शन आगे उन्होंने बताया कि बच्ची सैदा खातून मिट्टी का जो शुरू से की दूसरी पत्नी थी.
इनकी दूसरी पत्नी थी ना, पत्नी जो ये विक्टिम है वो भी मैरिड है, कहाँ से बोल रहे हैं?
उसके बाद आगे उसकी बातों में आकर ये करीब 2 माह पूर्व सैदा ने अपने पहले पति से तलाक ले लिया था. उसके बाद से उसका बुलाकर शादी कर. उसके आगे भगाने के कुछ दिन पहले दोनों वापस आकर सैदा के दादा अबू सामा के घर में बल्लभपुर में रही. वहाँ भी शुरू से सैदा खातून को प्रताड़ित करता है.
No marriage was performed. Marriage was not performed. Custody.
कस्टडी 13/8/2025. No criminal incident.
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that, as per the allegation, petitioner and the victim have been living together for how many months?
3 months. Yes, sir.
For 3 months prior to the alleged occurrence, and the victim had committed suicide. He has further submitted that it has been alleged that victim took divorce from her first husband on the promise of marriage made by the petitioner, and the petitioner was already married. पोस्टमार्टम रिपोर्ट में कोई इंजरी नहीं है. The learned counsel has further submitted that there is no sign of any assault on the body of the victim, and she died due to asphyxia. Counsel for the state has opposed the prayer for bail. After hearing the learned counsel for the parties and considering the aforesaid facts as stated by the counsel for the petitioner and not disputed by the learned counsel for the state, the petitioner is directed to be enlarged on bail.
Item में
चार्जशीट किसने हुआ है? मर्डर का हुआ है कि सुसाइड का?
Suicide का abatement of suicide.
That is under section
108.
108 में चार्जशीट हुआ है. कहाँ से बोल? केस डायरी 108.
Second page of
108 is abatement to suicide.
item 11. Item 11 DA 521 of 2026.
Is studied in the procedural procedure. Is studied in the procedural.
मेरा नाम सचिन सच है। आपका निवेदन को कहना है कि मेरा प्रेम प्रसंग लगभग 2 साल से विशाल कुमार यादव जिला देवर के साथ था। विशाल यादव शादी का झांसा देकर कई बार मुझे बलात्कार किया। शादी संबंध बनाने के क्रम में उन्हीं से मेरा वीडियो बना रखा था। यह बात मुझे मालूम नहीं था। जब भी मैं विशाल को शादी के लिए बोली तो वो मुझे कोई बहाना करके टाल देता था। इधर दिनांक 8/5/2025 को मेरे माता पिता मेरी शादी राजेंद्र रमानी पिता सचिन सच के साथ हिंदू रीति रिवाज के साथ कर दिया। ससुराल में भी विशाल मुझे फोन करके परेशान करने लगा और
Yes, who is the informant? Are you the informant? बताइए क्या बोलना?
The Lord initially petitioner established physical relationship on pretext of marriage, and Lordship, without her knowledge, he made video of the victim, and he's blackmailing her using that and made the video go viral. She is a married. Thereafter, she was married to some other person, namely Ranjit Ramani. Still, he is pressurizing her to establish physical relationship.
We'll ensure we'll give you protection. आप बताइए क्या बोलना है? From this petition? Where is
He has
it?
also refused to get DNA test.
Sorry?
Petitioner did not.
The
He
petitioner is
refused to get DNA test. He has refused. And the victim was willing to get DNA test.
वो गर्भवती हो गई. And they went to Gujarat also. Where is the case diary? You filed your contract.
Yes.
Where is the case diary? Case diary.
paragraph 35 of the case diary. The doctor has opined that the victim is 4 months pregnant. Further confirmation plus pregnancy with DNA analysis to confirm biological father of the case diary.
The child has been born. उसका DNA टेस्ट तो हो ही रहा है. This is under DNA test. The DNA test of the child is being performed. Who has refused DNA test? The petitioner.
The petitioner.
Have you refused the DNA test?
That is section language.
Hmm?
That is section language.
Instruction लेकर आइए.
But he is reading why you deny it.
नहीं आप instruction लेकर आइए. If he is ready for DNA test, it will be done. What's the big deal about it?
My lord, the petitioner has also made a video of her and is blackmailing her that he will make the video go viral. And using that, he's pressurizing her to establish physical relationship with him. Victim is a married lady, ससुराल में भी कॉल करते होते हैं कि वीडियो है.
Heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that. The petitioner is in custody since
Since 3rd of December 2025.
3rd December 2025 and has no criminal antecedent. ऐसे cases criminal antecedent भी होता है. He has submitted that. As per the FIR, the petitioner raped the victim repeatedly under false pretext of marriage and had also made a video. However, the victim was married to another person and the victim had become pregnant through the petitioner. And the petitioner has been blackmailing the victim. The learned counsel for the petitioner has submitted that the child has been born and he is ready for the DNA test for his paternity. लिखें कि नहीं लिखें? लिखें कि नहीं लिखें? Yes or no? Sorry? ठीक है, आप आइए. पेटर्निटी टेस्ट के लिए तैयार होंगे तो पेटर्निटी टेस्ट के बाद आपका बिल कंसिडर करने का ऑर्डर कर दूंगी, नहीं तो ऐसे ही रिजेक्ट करेंगे. एकदम क्लियर, ठीक है ना? आइए पास ओवर कर लें. 1 बजे आइए.
Item 12, BA 1067 of 2026, along with item 13 and 14.
I have considered another because of BNS one mobile phone and one SIM has been recovered from the possession of the present petition. The state has filed a counter affidavit. In the counter affidavit at para 13, it has been stated that
First we will take up 1268. इसका केस
12687 is mine.
मेरा 14 मिनट.
1268, BA number 1268. Sartajan sir. No victim, no antecedent, is that correct?
No one, no victim, only two SIM and one mobile was seized from his possession. One of the SIM was registered in the name of some another person. When well contacted, he said that he had no knowledge about that SIM. But several key values were generated on the other SIM.
The person in whose name the mobile was there, he had no knowledge about this.
No.
But no phone calls has been made from that number.
Yes.
Not a single phone call has been made.
Custody कब था?
And custody in manner 21/12/2025. Charge sheet has been submitted without making him the witness. Without making that particular person whom he said that that SIM belongs to that X person. He has not been made party, and he has been identified as a genuine person. Who notice के जवाब में
आप देखिए, इतना दूर जाना बहुत मुश्किल है आपके लिए, क्योंकि आपके यहाँ पास से रिकवरी है of SIM which does not belong to you.
does not belong. Police.
That is also sufficient, isn't it?
But that doesn't lead.
You don't account for it.
Yeah, madam.
इसीलिए आपके कोई एंटीसीडेंट नहीं है, कोई विक्टिम नहीं है, should be sufficient to grant you. जितना कम लिखा है उतना कम, उतना अच्छा. BA number 1268 of 2026. Third, the learned counsel is appealing on behalf of the parties. The learned counsel for the petitioner submits that, except recovery of mobile and SIM, there is no further material against the petitioner. The petitioner has no criminal antecedent, and no victim has come forward to have been defrauded by the petitioner. The learned counsel for the state, while opposing the prayer, has submitted that the SIM was registered in the name of some other person. However, the fact that no victim has come forward and the petitioner has no antecedent is not in dispute. After hearing the learned counsel for the parties, and in the light of the aforesaid facts and circumstances, and his custody since 21/12/2025, the petitioner is directed to be enlarged on hearing. अब रजूल अंसारी 1067 Rajaul Ansari.
My lord, in this case there is recovery of one SIM and one mobile. My lord, in para 13 of the counter affidavit, it has been stated that from 57 to 59, it has been shown to be that three persons
ये
have
वाला
been
देखिए रजाउल अंसारी वाला केस ये है. हाँ, पैरा
from para 13 of the counter affidavit. That three persons are the victims. Now, in this case, the charge sheet has been submitted, my lord. Three persons have not been made as a charge sheeted witness, my lord. Then how they will prove that they have been cheated, my lord?
I got the copy of the charge sheet. These three persons have not been made as a charge sheet witness for the reasons best known. Only one person with regard to Maniruddin has been made as a charge sheeted witness, that is, and with regard to these three persons, this Kesava Murthy M, then Ranjit Singh, and Agamatullah, all are not charge sheeted witness. And with
IO
regard
has sent
to
letters for remand of the accused to the concerned police station.
pardon me,
आपने क्या they have, once they record cyber offense in some other place, you become an offense or accused in those cases also, no?
I'm not been made an accused in any of the cases. A specific statement. He is the only case here, and through cyber portal they are doing it, and they are calling telephonically. And what is the thing that they are writing in the case diary? It's not they are not examining also by going there or asking them elaborately. Nothing. Telephonic, that in the cyber portal there is a number.
Whenever any statement of a witness is recorded, it is also recorded orally only.
Orally not signed. But
So
obviously
therefore,
it is signed,
not
then it's
signed,
not
that
under
is-
162.
So
I'm not on
therefore, that
one.
doesn't make any difference
that-
whether they are saying telephonically
telephone
or whatever.
I'm only on this one whether they are essential witness to prove my guilt during trial. They have to be made as a charge sheeted witness, man.
Yes, you do not make them witness. Where is the charge sheet?
Yes. मेरे पास है
आप इन लोगों को विटनेस नहीं बनाते हैं?
नहीं बनाए दिखा दे रहा
चार्जशीट मंगा लिए
है charge
एक को बनाया है लिखा
हाँ उनको मेरे लिए नहीं मेरा नहीं है मनिरुद्दीन का 3 आदमी है that is केशवा मूर्ति एम रंजीत सिंह रागामातुल्ला यहाँ पर भी लिखा गया मगर चार्जशीटेड विटनेस नहीं है
इसमें एक चार्जशीट में लैंग्वेज लिखा तथा अन्य कुछ लंबी तकनीकी पर पूरा अनुसंधान जारी
पूरा अनुसंधान just but charge sheet has been submitted but पूरा अनुसंधान charge-sheeted witness has been given 173(8) they can file charge sheet at any time.
इन लोगों का अभी स्टेटमेंट नहीं रिकॉर्ड किया है ना, इसीलिए इनको अभी विटनेस नहीं मिला। स्टेटमेंट नहीं रिकॉर्ड किया।
स्टेटमेंट रिकॉर्ड किया है।
कहाँ है स्टेटमेंट?
इसका स्टेटमेंट रिकॉर्ड है। स्टेटमेंट रिकॉर्ड किया है।
पारा 59 में 69
59
69 में मनिरुद्दीन का लिप्सा प्रधान का
वो 6
नहीं, वो
मेरा
लिखा
मेरा
था। बाकी इनके उनका किसी का स्टेटमेंट नहीं रिकॉर्ड,
स्टेटमेंट
इसीलिए ये चार्जशीटेड विटनेस नहीं है एंड द इन्वेस्टिगेशन इज स्टिल ऑन।
पीड़िता का शिकायत आवेदन पर आधार पर अनुशंसा आवेदन कार्रवाई डिमांड हेतु पुलिस अधीक्षक कराची तमिलनाडु से
कॉरेस्पॉन्डेंस किया गया।
नहीं कॉरेस्पॉन्डेंस
माध्यम से पत्राचार किया गया और इस कांड के प्राथमिक अभियुक्त मनिरुद्दीन का भी इसका भी स्टेटमेंट नहीं किया है, मंत्री को चार्जशीट बना दिया।
59 में इनका आया मामले
इनका और उसके बाद तो लाभ
इसलिए तो मेरा
ना नहीं जो उसका उनका वाला भी है
59 में क्लियर देखा हुआ
पुलिस विभाग का चल रहा है
72,93 रुपये हमारे
and one antecedent matter that is under 135, 136 I have been acquitted matter by giving the fines. I got the document also. Electricity articles.
compounded
Compounded.
acquittal नहीं।
Acquittal.
एक्यूटल
नहीं है, एडमिशन है, मतलब 131 हम बता रहे हैं, एक्यूटल नहीं है।
ऐसा भाषा का प्रयोग
नहीं नहीं, एक्यूटल वर्ड एकदम गलत है। I pleaded guilty, I pleaded guilty. Now I'm clear. I pleaded not acquittal one. I pleaded guilty and deposited the fine. गलती से वैसा भाषा कैसी
ऐसा बोलते हैं तो हमको लगता है आप कुछ और ही सोच रहे हैं कोर्ट के बारे में।
नहीं, आप pleaded guilty मतलब आप I should have pleaded guilty.
क्या बोलना है आप?
क्वेरी किया गया था कभी कि whether that is come under the organized crime or not. First, I want to read the confessional statement of one of the accused of sin. मैं लालच में आकर अजाऊ सरताज के साथ साइबर ठगी का काम करने लगा। साइबर ठगी के लिए हम लोग फोन पे में 10 डिजिट का मोबाइल नंबर डालकर फोन पे यूजर पता लगाते हैं। उसके बाद हर जगह हम लोग यूज नहीं किया हम। उसके बाद मोबाइल एक एवं दूसरे व्यक्ति के नाम पर सिम फर्जी तरीके से प्राप्त करते हैं, मैसेज भेजते हैं, फिर यूजर को फोन करके बोलते हैं कि अपना फोन पे में इतना का कैशबैक आया है, रिसीव करने के बाद अपना बैलेंस चेक कीजिए। यूजर जैसे ही कैशबैक का मैसेज करता है तो हम लोग का मैजिक और रूट कार्ड एक में पैसा आ जाता है। उस पैसा को हम लोग फ्लिपकार्ट अमेजन गिफ्ट कार्ड बना लेते हैं और ऑनलाइन शॉपिंग कर लेते हैं। उसके इनके अलावा साइबर ठगी का
ये सारा का सारा
ये करके हम लोग सेकेंडली दे आर जॉइंटली अरेस्टेड फ्रॉम सेम प्लेस ऑफ ऑपरेशन।
Let us see organized crime. If for commission of one offence, यानी कि for commission of one incident, किसी के अकाउंट से चोरी में अगर उस पर्टिकुलर अकाउंट से चोरी में 2 लोगों का इन्वॉल्वमेंट हो जाएगा कि एक ने फोन किया, दूसरे के अकाउंट में ट्रांसफर हुआ, एंड तब आएगा ऑर्गेनाइज। अगर 4 लोग मिल जाएं, एक साथ बैठ जाएं, अपने अपने फोन पर ये कांड करें जिसमें आपस में तो कोई लिंक नहीं है। एट द टाइम ऑफ कमीशन ऑफ ऑफेंस भाई 2 आदमी मिल के ऑफेंस कर रहे हैं, मिल के मतलब साथ बैठ के ऑफेंस कर रहे हैं। साथ बैठ के ऑफेंस करने का मतलब ये नहीं होता है कि मिल के ऑफेंस कर रहे हैं। देयर इज अ डिफरेंस बिटवीन द टू। इफ 2 people say that I am going to Ratu Road to commit theft and I am going to Balban compound to commit theft, 120 भी लग जाएगा।
इसमें 120 भी
लगेगा? लग जाएगा कि हम वहां जा रहे हैं, वहां जा रहे हैं। नहीं लगेगा ना,
सेक्शन 10 का हाथ में नहीं लगेगा,
नहीं लगेगा ना। तो यहाँ पर वो लिंक कहाँ है ऑर्गेनाइज्ड? आई एम नॉट एबल टू फिगर आउट। कैन दिस ऑफेंस, could this offense be done by each of the individual person sitting separately at home? फिर एक जैसे लोग साथ मिल जाते हैं वो अलग बात है, लेकिन ये ऑर्गेनाइज्ड क्राइम कैसे है ये हमको नहीं समझ आता।
एक साथ बैठे और
लेकिन एक साथ एक पर्टिकुलर फ्रॉड में इन्वॉल्वमेंट नहीं है, वो नहीं है ना।
लेकिन सब ये लिखे कि हम लोग साथ मिलकर करते हैं।
साथ मिलके मतलब एक साथ बैठ के करते हैं, साथ मिलके सारे एडवोकेट लोग हैं, तो ऐसा थोड़ी है कि एक एडवोकेट। आप ऐसा बात बोल रहे हैं जैसे कि आप इस केस में अपीयर हो रहे हैं, बहुत सारे एडवोकेट साथ बैठे हैं, ऐसा थोड़ी है कि सारे एडवोकेट मिलकर केस कर रहे हैं। इट इज नॉट लाइक दैट। इफ 100 people they sit together and sit with their independent phone and they commit offense independently through their phone, तो ऑर्गेनाइज्ड क्राइम कैसे? ईच वन ऑफ देम इज गिल्टी, देयर इज नो डाउट। लेकिन कोई भी एक पर्टिकुलर ऑफेंस में यू एक्सप्लेन, आई वांट टू नो ये ऑर्गेनाइज्ड क्राइम कैसे हुआ होगा।
ऑर्गेनाइज्ड क्राइम में और है कि रिपीटेड ऑफेंस होना।
हाँ,
रिपीटेड हियर देयर इज द रिपीटेड ऑफेंस।
नहीं, ऑर्गेनाइज्ड क्राइम में रिपीटेड ऑफेंस नहीं आता। डेफिनेशन देखिए ऑर्गेनाइज्ड क्राइम का, 2 आदमी होना चाहिए मिनिमम। रिपीटेड ऑफेंस में जैसे 379 में एक केस हो गया, 2 केस हो गया तो 6 महीना बाद भेज देंगे, पहले चलता था 9 महीना बाद भेज देंगे।
वो 413 है, जो 413 जिसमें एंटीसीडेंट्स होगा तो उसमें
वो अलग चीज है।
वो है कंटिन्यू अनलॉफुल एक्टिविटी, कंटिन्यू अनलॉफुल,
दैट इज अ सेपरेट थिंग, दैट इज नॉट ऑर्गेनाइज्ड ऑफेंस। वो तो किसी का क्रिमिनल एंटीसीडेंट सिमिलर नेचर का होगा तो हम उसका बेल इस ग्राउंड पे रिजेक्ट कर सकते हैं कि सिमिलर नेचर का है तो ही इज अ रिपीट ऑफेंडर। of the same nature. But that will not become an organized crime. Organized crime is very serious.
111 में ही है, 3 organized crime syndicate, एक ग्रुप होना चाहिए जो क्राइम कर रहा है, एक syndicate बोल रहा है कि organized crime syndicate, meaning there are a group of some persons who are doing crime. Second thing होता है continuing unlawful activity. Continuing unlawful activity है दूसरे मोबाइल को अपने सिम में यूज कर रहे हैं, identity theft है, stolen property को यूज कर रहे हैं.
Organized crime में लिखा है to commit the crime 2 persons should be there. Minimum.
Yes.
Right?
Group of
Each-
two or more.
2 or more. Merely because 2 criminal-minded persons are sitting together
Yes.
and committing independent crime, will it become organized crime? ये कहानी, यही हम सोच रहे हैं.
हमको भी थोड़ा और रिसर्च करने की जरूरत है.
थोड़ा रिसर्च करने की जरूरत है क्योंकि ऑर्गेनाइज क्राइम का पनिशमेंट बहुत सीरियस है. और ये जो फर्जी सिम बना के करते हैं इसमें भी लाइफ है. पहले 468 में 7 years ही होता था. फोर्जरी फॉर चीटिंग ओनली 7 years was the maximum punishment. Now under BNS it is life. 338 is life.
338
हाँ देखिए देखिए.
एक फॉग है, नॉन फॉग है.
नहीं दिखाई दे.
67
ये
468 में. पेरिस 468 में. 338 का 1 2 करके है.
338 का 1 2 करके नहीं.
338 में 1 2 नहीं है, मैक्सिमम 10 years किया.
338 का फॉर्जरी में वैल्यूएबल सिक्योरिटी और वेल एक्सेट्रा.
सिक्योरिटी
उसमें लाइफ
भी है.
लाइफ है
10 years भी है.
दोनों.
You see, and when you are buying a SIM in somebody else's name, right? In a person, not you. If a person is buying a SIM in somebody else's name, he is committing forgery to obtain a SIM to commit a crime. We are just thinking that what are the ways and what sections are to be attracted under such
For
circumstances.
forgery, one thing, making of a false document is a very sine qua non. Means false document I am preparing and who is verifying it, madam? Now everything is very clear. Without Aadhaar,
SIM नहीं without biometric SIM नहीं मिलता है.
ना नहीं मिलता है.
कैसे बोलते?
Biometric
आधार देने से SIM मिलता है.
नहीं, बायोमेट्रिक्स मैच कराना पड़ता है.
नहीं आप जाइए SIM लेंगे. नहीं
अभी रिसेंटली हम आपने किए तो हमको पता कि बायोमेट्रिक में लेना पड़ा.
बायोमेट्रिक्स में नहीं लेना पड़ता.
आई नहीं रहा
SIM
अब
बंद कर दिया.
हाँ बंद कर.
बंद कर दिया. जो आज जो मेरा वाला है ना, ये इसी समय का बंद करने के बाद वो हम नहीं बोल. बायोमेट्रिक हम खुद दिए इसीलिए हम बोल रहे हैं. अभी बिना बायोमेट्रिक का नहीं हो रहा है.
और कोई एंटीसीडेंट तो नहीं.
नहीं कोई एक्सीडेंट नहीं. कोई एक्सीडेंट.
ठीक. Heard the learned counsels appearing on behalf of the parties. इसका लिखिएगा Rajaul Ansari. The counsel for the petitioner submits that the petitioner is in custody since 21/12/2025 and has no criminal antecedent. He has further submitted that although it is alleged that there are 3 victims, but in the charge sheet, none of the victim has been made as charge sheeted witness. He has further submitted that no case of organized crime is made out against the petitioner. As even as per the allegation, nobody else had participated along with the petitioner for commission of the alleged offence, so far as it relates to the petition. The learned counsel for the state has opposed the prayer and has submitted that 3 victims have been defrauded by the petitioner by using phone and SIM, and SIM was registered in the name of another person,
Another person name is.
नाम देने का जरूरत नहीं. After hearing the learned counsel for the parties and considering the fact that the petitioner has no criminal antecedent and he is in custody since 21/12/25, the petitioner is directed to pay enlarged on leave.
नेक्स्ट में सिमिलर है लेकिन एक टू इनका victim है उसका चार्जशीट
कोई incident नहीं है. Custody same हो गया. Mobile belonging to other person.
आपका तो विक्टिम चार्जशीट है. कितना है आपका केस आपके केस? नो विक्टिम.
No, only one case में लोग discuss.
एक तो है जो चार्जशीट
विक्टिम कितने?
एक victim
Only one victim, but she has been charged.
थ्री है लेकिन वन विटनेस जो है वन विक्टिम चार्जशीटेड विटनेस है. देयर आर थ्री विक्टिम्स आउट ऑफ वन ईच चार्जशीटेड. Who have been examined during investigation.
No antecedent?
No.
Custody?
Custody
Same.
same. It is one.
Or the learned counsel is appearing on behalf of the parties. The counsel for the petitioner submits that he is in custody since 21/12/2025. And as per the allegation, there are three victims. The petitioner has no criminal antecedent and he submits that no case for organized crime is made out of this petition. The learned counsel for the state has submitted that out of the three victims, one is the charge-sheeted witness. However, the custody and the fact that the petitioner has no criminal antecedent is not in dispute. Considering the aforesaid arguments and the custody of the petitioner since 21/12/25, the petitioner is directed to be enlarged in the legal case.
Item 15, BA 1281 of 2026.
You have a similar case against you of similar
One
nature.
incident में victim
Antecedent है आपका.
victim है.
Repeat offense पे बहुत मुश्किल है. पास ओवर कर दो. जेल से निकल के दोबारा करने का मौका नहीं देंगे.
Item 16, BA 1863 of 2026.
Yes. पास ओवर. पास ओवर. कल भी पास ओवर हुआ था. दोबारा फिर एक बार पास ओवर होने के बाद तो कोर्ट में थोड़ा अटेंटिव रहना चाहिए ना.
From the daily list under heading for fresh filing, item 1, BA 2748 of 2026.
Silent matter also. Tomorrow one of the cases was listed in the BA number 2461 of 2026. The tag along with the BA number 2748 of 2026.
Post this case with the BA number 2461 of 26, which is already directed to be listed on 29/4/26. Counsel for the state is directed to file counter affidavit and with antecedent report of the petitioner. उसमें केस डायरी आया हुआ है.
नहीं नहीं वो भी फ्रेश है
नहीं 2461
2748 में 2748
The order of public.
हाँ 2748 का ऑर्डर है 2748 अच्छा यही था ना इसका ऑर्डर निकालिए 2461 का ऑर्डर 2461
उसको देखना
अभी देखते हैं 2461 ऑफ 26 का ऑर्डर निकालिए टू सिक्स फोर नहीं 2461 कॉल फॉर केस डाइजेस्ट में हुआ है ठीक है और उसमें एंटीसीडेंट रिपोर्ट कॉल फॉर इसमें काउंटर फाइल कर दीजिए उसमें भी फाइल कर दीजिए 29 और भी है कोई मैटर इसमें दिखाई 3 मैटर है तो ये तो एक हुआ
एक कल लगा हुआ था DA.07.04
वो चला गया है
वो चला गया
Item 3 DA.27.51 of 2026.
Yes, petitioner.
Daily list item 3.
The case of cyber abuse. The first one matter is
Counsel for the state is directed to custody कब से आपका?
on custody since 20 to 26.
Counsel for the state is directed to produce case diary and file a counter affidavit along with criminal antecedent of the petitioner. The case diary should be submitted to this court at least 2 days prior to the next date. Post this based on 30th.
Item 4 DA.2753 of 2026.
साइबर का साइबर के लिए और से केस और से 3% हैव बीन एप्लीकेंटेड उसमें तो फिर एक आदमी को फिर बेल हो गया एक आदमी को डायरी मांगे का पुलिस ये का सिंगल में बेल तो का
किसका डायरी मांगे और कब है डेट इसमें?
प्रोसीड
कल है ना?
हाँ कल
इसमें आ गया डायरी
हाँ तो उसमें कॉन्ट्रैक्ट है बीए नंबर
1861
शिमला मुझे का बेल भी हुआ अभी उसमें मुझे
like
शिमला नहीं
post this case tomorrow.
इन्हीं पे ज्यादा ट्रांजैक्शन वगैरह से नहीं पड़ता
Post this case tomorrow along with BA number 1861 of 2026. कल सुनेंगे दोनों साथ में सप्लीमेंट्री लिस्ट में रहेगा ये मैटर और वो जहाँ भी लिस्ट में रहेगा आपका उसी समय सुनेंगे साथ
Item 5 DA.2756 of 2026.
This is cyber abuse.
Post on 29/4/2026 along with BA number 2807 of 2026. Counsel for the state is directed to file a counter affidavit in this case, along with criminal antecedent report. उसमें एक केस डायरी आया है? Are you sure? Order दिखाइए 2807 of 26. 2807 of 26. Order दीजिए. ऑर्डर अपलोड नहीं मेरा कोड का ऑर्डर टू एट जीरो सेवन
Yes, 2807/2026.
कहाँ से ऑर्डर हुआ 2807 is listed today.
Yes.
Yes, today listed, today.
Where is it? Item number?
Serial 31.
Main list.
Yes.
Okay.
Daily list.
एक सेकंड ये ना दोनों केस एक साथ करेंगे ये वाला फिर से लिखिए तो BA number 2756 of 26 with BA number 2807 of 26. These two cases arise out of the same FIR. The learned counsel for the state is directed to file counter affidavit and file along with criminal antecedent report of the petitioner and produce case diary. The case diary be submitted to this court 2 days prior to the next date of listing, post on 30th.
Item 6, DA2757 of 2026.
Case at serial number 6, 7 and 23. They arise out of the same FIR. Counsel for the state is directed to file counter affidavit along with criminal antecedent report of the petitioner. आप प्रोड्यूस करेंगे आपका नाम लिखें केस डायरी आप प्रोड्यूस करेंगे मिस्टर स्वयं नाम बताइए सॉरी Sailesh Kumar Sinha is directed to produce case diary before this court and hand it over to the court at least 2 days prior to next date of listing. Post on 30th.
Item 8, BA2761 of 2026.
Twice earlier, their appeal was rejected, page 1718. Then was page 32 is in an order the Supreme Court liberty was given. But page 33. Procedural, however, the trial court is encouraged to expedite the trial. There is no substantial progress in the trial during the course of the next 3 months, despite the cooperation extended to petitioner. If there be any chance of starting petition, however, all the witnesses have been examined, and as it would appear from the impugn order that it was fixed for argument on 19/3/26. But Mr. Shekhar Kumar, additional sessions judge were transferred. Now
We are trying to find out whether the post is vacant. You wait for some time. जरा आरडी से पता करिए कोई और आए हैं कि नहीं सक्सेसर को आरडी को सुबह मैसेज किए थे इस केस के लिए Have you received information?
सौरभ जी दिए हैं कि कुछ इन्फॉर्मेशन
Shekhar Kumar, मेरे पास ट्रांसफर ऑर्डर है
So he will be shortly joining. Allegations are very serious. Now there is already a person has been transferred. He will be shortly joining.
The allegation had been that because we informed the informed party that she hanged herself. Because their allegation, the FIR had been that we poisoned her and we hanged her. Because Visra report has come, because there is no substance found, so that allegation is falsified. Yes, because she got hanged herself. This is the fact, because we have been saying since beginning. So that is the pattern of the witnesses also which have come. Rest of work.
I heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner has submitted that although there is allegation that the victim was poisoned and she was hanged, but as per the Visra report, there is no sign of poisoning. You are the? Well, how are you related to the victim?
I'm the husband.
The petitioner is the husband of the victim. The bail application of the petitioner was rejected twice earlier by this court. Once in DA number 2883 of 2025 by order dated 11/7/2025, and then in DA number 9530 of 2024 by order dated 17/12/2024. She was found dead in her matrimonial home. The learned counsel has submitted that the petitioner had also moved the Honorable Supreme Court, and the Honorable Supreme Court refused to interfere with the order rejecting bail, but directed to expedite the trial by observing that at that point of time there was no progress in the trial. The order of the Honorable Supreme Court is dated 30/10/2025. The learned counsel submits that thereafter the witnesses have been examined and the case was at the stage of argument on 19/3/2026, but on account of transfer order of Shekhar Kumar, the matter could not be heard. And the petitioner is unnecessarily languishing in jail. It has been informed by the learned RG that Shekhar Kumar ADJ Sahibgan has been transferred, but the charge has not yet been given. In view of the aforesaid facts and circumstances, there is इनकी जगह ट्रांसफर हुआ है तो किसी का तो होगा ना?
वहाँ दिए नहीं, ऐसी वैकेंट है।
चार्ज नहीं दिए हैं, वैकेंट है, ऐसा दोनों चीज कैसे होता है?
कोर्ट वैकेंट है, कोर्ट वैकेंट। अब तो जब भी जो आएंगे वो रीहियर करेंगे।
अभी तो हियरिंग शुरू ही नहीं हुआ ना।
हाँ, आर्गुमेंट होगा फ्रेश, क्या शुरू हुआ था लेकिन चल रहा। बोले भी थे वो कि
However, considering the fact that after the order of the Honorable Supreme Court dated 30/10/2025, the trial has concluded and it is at the stage of argument, and the petitioner and there is direct allegation against the petitioner, and his bail has already been rejected twice by this court. this court is not inclined to enlarge the petitioner on bail. However, it is directed that the अब इनको हम कैसे डायरेक्शन दें? ही इज अंडर ट्रांसफर ऑर्डर.
हमको खाली लिबर्टी दे दीजिए कि दो
If the arguments are not concluded by the concerned court, the petitioner may renew his bail. And still the court remains vacant. The petitioner may renew his bail, prayer for bail after 3 weeks. Communicate the parties to cooperate with the final arguments.
Item 9, DA.07.04 of 2026.
Yes, petitioner.
FIR under section 87, 303, 351, 352, and minor of the allegation minor page number 50. They are permitted. एलिगेशन है कि हमारे 15 इयर्स बेटी को घर से ले गए, एक एलिगेशन. बट माय लॉर्ड, इन कोर्स ऑफ द इन्वेस्टिगेशन a statement of the victim recorded, my lord, under paragraph number 30 of the case diary, and she stated कि मेरा एज 17 to 18 17 इयर्स है और हम स्वेच्छा से इसके साथ में गए हैं और हम लोग स्वेच्छा से दोनों साथ में. एज जो है वो मेडिकल के लिए वो डिनाई की है और एज उसका 17 to 18 बीच में है एज पर दी केस डायरी.
कहाँ है केस डायरी?
केस डायरी आई है.
आप रखिए अपना केस डायरी, हम तो आपका केस डायरी नहीं पढ़ सकते. आप एक्यूज का केस डायरी हम कैसे पढ़ेंगे? मंगाना पड़ेगा ना. Call for the case diary along with the statement of the victim. And also the document relating to document, if any, document/medical examination of the victim regarding her medical examination of the victim. आप बोलते हैं 18 साल के हैं.
नहीं, 17 to 18.
आपका एज कितना है?
मेरा एज 18 है.
कहाँ है? कोई डॉक्यूमेंट है?
डॉक्यूमेंट
Counsel for the petitioner is also directed to file a supplementary affidavit showing that he is 18 years of age. Counsel for the state is directed to file a counter affidavit. Post on 30th April.
Item 10, DA.07.06 of 2026.
Sort of on the minor actually under section 6 of Oxford.
Very serious allegation.
And the surprising thing is that in this project they are neighbors. And in the village election,
नेबर्स में तो ज्यादा प्रॉब्लम है.
and
बच्चियां सबसे ज्यादा अनसेफ नेबरहुड में ही है और उससे भी ज्यादा अनसेफ आजकल घर में होगी.
age of the petitioner is 50 years.
15 years and our petitioner is 50 years.
Petitioner is 55.
50 साल.
Victim is 11 years.
Victim is
11 years.
11 years. Not a case.
One time case diary because there
Not
is
required.
as per the in the
एलिगेशन बहुत सीरियस है. देखिए अच्छी बात नहीं है. आपका केस रहता है तो खराब केस नहीं है. सब थोड़ी बहुत सीरियस. BA number 2766 of 2026. Heard the learned counsel submitted on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner has been falsely indicated in this case, and there is delay in filing the FIR. The learned counsel for the opposite party has opposed the prayer and has submitted that there is serious allegation against the petitioner who is aged 50 years and the victim is just 11 years of age, and it is alleged that the petitioner had repeatedly raped the victim, and the delay is explained in the FIR itself that because of social stigma there has been some delay. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, which is very serious in nature, the court is not inclined to enlarge the petition on bail.
One more submission for the petitioner. As per the examination of Dr. No sign of.
That's he has also submitted that as per the examination of the doctor, there is no sign of rape. State का submission में लिखिएगा. Since there is some delay, there was no occasion to have any sign of rape at the time of medical examination. क्या चल रहा? चार्जशीट हो गया?
चार्जशीट हो गया, कॉम्बिनेशन है तो
After trial expedite करा. At this, the counsel for the petitioner has submitted that the trial may be expedited. Charge sheet has already been submitted and cognizance has been taken. The counsel for the state is directed to ensure that the witnesses are promptly produced once the trial commences. The counsel for the state is directed to communicate this order to the superintendent of police of the concerned district and also to the director of district.
Item 11 DT.07.04.2026.
The case under section 65(1) of the NL and 4 and 6 of the Constitution. According to prosecution case, it has been informant saw her his daughter that she was upset and suffering from some kind of illness. Thereafter, she was taken to the doctor, and it was detected there that she had 7-month pregnancy. Thereafter, her mother asked about the same, and she disclosed that prior 8 or 9 months or 1 year, she was repeatedly making sexual intercourse by the petitioner, this petitioner. And thereafter, my lord, it is important to say that in spite of the request of the petitioner, there was no DNA test was and no FSL report, my lord, and the age of the victim could not be assessed by. The charge sheet has been submitted in this case, my lord. It has come in the UP order itself.
No, it's in 27, page not 27, lordship, it has come in lordship.
13/11/25. उसके बाद से क्या हुआ? नवंबर के 6 महीना बीत गया. क्या हुआ 6 महीना? What happened in 6 months?
No, the charge has been framed and the case is pending for evidence, my lord. But
How
no
many
evidence-
witnesses have been examined?
No witness. And it has come in the UP order, my lord, on the request of petitioner himself, no DNA test was done. No FSL report is available.
15 years, lordship, it has come in
Age of the victim is 15 years.
15
आपके
years, 15 years कैसे है हुजूर? कि she has stated and the magistrate has assessed her age as 15
the
years.
child has been delivered. तो पैटर्निटी टेस्ट के लिए आप तैयार हैं?
तो हम तो सर रिव्यू ऑर्डर में लिया है.
उस समय तक तो डिलीवरी नहीं हुआ होगा ना, तो किसका डीएनए टेस्ट किसके साथ मैचिंग होगा? जब बच्चा आ जाएगा तभी होगा।
He throughout in custody.
That's right.
मेडिकल रिपोर्ट भी सर हम अपना लगाए हैं, तो मेडिकल रिपोर्ट भी देख ली जाए, उसमें देयर वाज नो असेसमेंट ऑफ एज. She was not medically examined for the purpose of assessment of age. And kindly look into the statement made by her under section 183 main assess. She only said that he was making a relationship with me और हम उसको मारते भी थे.
काफी नहीं,
तो पर मारते भी थे उसको.
काफी नहीं है.
It is
There is a statement of
consensual, minor consensual relationship.
Consensual.
Age is otherwise, but
कहाँ है वो इनका स्टेटमेंट?
पेज 17 देख एक लाइन इसको सपोज करता है कि हम मारते भी थे उसको. There was something between them.
आपकी बात हमको नहीं समझ आ रही, आपको समझ आ रही. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since
3/7/25.
3/7/25 and is aged 27 years. But he has been falsely implicated in the case on the alleged repeated rape of victim said to be 15 years of age. He has also submitted that the victim became pregnant, but the police did not conduct his DNA test and no FSL report is available on record. The learned counsel has also submitted that as on date, the child has been born and the petitioner is ready for paternity test. The learned counsel has submitted that as on date, charge sheet has been submitted, the charge has been framed, but no witness has been produced so far. Cognizance was taken as back as on 12/11/2025. Counsel for the state has opposed the prayer and has submitted that the victim has been examined under section 183 DNSS and she has fully supported the prosecution case. He has further submitted that if the petitioner wants paternity test to be conducted, he can file an application before the concerned court. है ना? कर सकते हैं ना? After hearing the learned counsel for the parties and considering the reported submissions and the direct allegation made against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, if the petitioner files in the petition for his paternity test, the same can certainly be considered by the court in accordance with law. The case is at the stage of evidence. The state is directed to produce the witnesses promptly before the court. Counsel for the state is directed to communicate this order to the SP of the concerned district and also to the director of prosecution for compliance. आप एप्लीकेशन दे दीजिए, आपका पैटर्निटी टेस्ट हो ही जाए.
Item 12, BA 2774 of 2026.
Counsel for the petitioner seeks permission to withdraw this petition. This petition is dismissed.
Signed. Item 30, BA 2777 of 2026.
Cyber crime, on behalf of one directive, case diary has been called for, and case is fixed for 29th April 2026.
Like, pose this case on 29/4/26 and tag it with BA number 2440 of 2026. The counsel for the state, in the meantime, is directed to file a counter affidavit. कौन है स्टेट के काउंसिल? मिस्टर शैलेंद्र तिवारी।
सेम है जो उसमें
ठीक है, इसमें काउंटर के लिए उनको बोल देंगे।
Item 14, BA 2780 of 2026.
Yes, file.
We accused 1529.
Pose this case on 24/2026 along with BA number 1529 of 26. The counsel for the state is directed to file counter affidavit in the meantime along with criminal antecedent.
Item 16, BA 2782 of 2026.
Under section 96, it is alleged by the mother that the petitioner has taken away her daughter. But as
Call for the
FIR is clearly mentioned that
call for the case diary from the concerned court along with antecedent of the petitioner. Counsel for the state is directed to file a counter affidavit post on 30th.
Item 17, BA 2784 of 2026.
Case under section 64/376 of the Act. See, this case law said that all the allegation and false and fabricated as the petitioner Lord said. Firstly, Lord said there is a delay of 2 years in lodging the FIR notes. Thereafter, Lord said, I have annexed Annex 2. The petitioner has solemnized marriage with the informant of 24/2/2023 laws. And then, after the informant has also given birth to the child, I have stated especially, Lord, that I am the child is
आराम से
wrong child.
अरे भाई पानी पिलाइए
नहीं
रुक जाइए पानी नहीं है यहाँ पर हाँ देखिए आपके लिए पानी बैठे
that I have stated parroting Lord said.
The petitioner has solemnized marriage with somebody else.
No, Lord. That he has stated and all the family member has been made an accused Lordship. I have not. I have stated specifically para 10 Lordship available. They are still willing to resume his conjugal life with the informant and child.
Where have you stated that you have not married him?
No, that I have not stated, but that I am stated that is still willing to resume his conjugal life.
Age 23 years has come, Your Lordship. Shirai Ansari also used to beat her and river, and after giving birth child, that the accused solemnized marriage with another girl.
May I submit one thing that has come in noon order? What has come? That is after investigation. Firstly, Lordship, kindly see the page 15 is complaint petition.
Directed to file a counter affidavit in this case.
In complaint petition, there is nothing.
Particularly indicating as to what material has come up during investigation that the petitioner has married with someone else. आपको paternity test कराना है?
नहीं, हमको लिखना मेरा बच्चा है. हम आया किसको?
Counsel for the petitioner has submitted that the petitioner has not performed any marriage with any another lady. Rather, he has performed the marriage with the victim. He gave birth to a child on 29/22. So he post on 30. However, such statement is not available in the bail application. The petitioner may file supplementary affidavit.
Item 18, DA2786 of 2026.
Lordship, yes, this has been dismissed as written Lordship after the summary. That is
BA number 2786 of 2026. Counsel for the petitioner submits that this is a tied up matter with another bench. He has referred to order dated 11th of March 2026, passed in BA number 1575 of 26. Office is directed to place this case before the Honorable Chief Justice on the administrative side for appropriate.
still on 19.
19 also. Serial number 19. Same. After some argument, है?
Yes. मतलब दोनों petitioner एक साथ फाइल किए
Withdraw लोग इतने क्यों किए?
सर पेडिविकार ने लिखे थे और एक साथ फाइल किए थे दोनों, ये दोनों एक साथ फाइल किए, अलग-अलग फाइल करते।
तो आफ्टर सम आर्गुमेंट कैसे लिखा? कुछ तो बहस किए होंगे आप?
बहस तो कर रहे थे, जो लिखते आप बेटर।
सेम ऑर्डर। क्योंकि हम बहुत सारे केसेस देख रहे हैं विड्रॉल।
24 नंबर सिस्टम।
कुछ तो गलती आप लोग जरूर कर ही रहे होंगे।
Item 20, DA2789 of 2026.
Case of cyber.
Counsel for the state is directed to file counter affidavit and produce the case diary. Counter affidavit with antecedent report of the petitioner and produce the case diary. For this case on 30th April, the CD should be submitted before this court. At least 2 days prior to the next date. कौन है इसमें? इसमें काउंटर फाइल कर दीजिए, 30 तारीख को रखेंगे। केस डायरी 2 दिन पहले देंगे। एक और केस में हुआ है, आपको काउंटर फाइल करने का ऑर्डर मिल गया आपको इंफॉर्मेशन?
Item 21, DA2790 of 2026.
It is also a case of cybercrime.
Same order? Is it to be tagged with any case?
No, no.
Isolated case? 30th one.
No accused, no petitioner.
30th one.
Item 22, DA2793 of 2026.
It has come in the order. all the family members have been implicated in this case. So charge sheet has been submitted only against this petitioner, and for the rest, police form is done. Even witnesses, there is a mention of witnesses.
This is direct allegation against you.
Yes, madam. There is direct allegation. He has attempted to commit. This was the allegation.
And you have been disturbing her while going to school also. School पे नहीं जाने देते.
These two allegations are there, and on that basis, madam, it is said, madam, that the entire family members were saying, "Ki you commit rape, and we will
Accept her
as your wife." So these are the circumstances that suggest, madam.
What is the reason for false allegation?
Madam, the reason is, madam, there was family dispute between the families, and because of this reason, this boy has been. Or otherwise, no family member will say such type of thing. Even lady member, all the family members, including lady member of the family, such type of allegation.
क्या बोलना? Attempt का है ना?
Specific, and he is custody since 10/12/2025.
एक बार और कर चुके हैं, इसके पहले FIR में
उसका कोई FIR किए थे? Or the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 10/12/2025, and it is alleged in the FIR that the petitioner outweighs the modesty of the victim, and all the family members of the petitioner had stated that even if the petitioner commits rape upon the victim, they will accept the victim in their family. And consequently, all the family members have been made accused in the FIR. He submits that ultimately the charge sheet has been submitted only against the petitioner. The learned counsel has further submitted that there is previous enmity between the parties and the petitioner has been falsely implicated. The counsel for the state has opposed the prayer and has submitted that time and again the petitioner has been disturbing the victim girl, who is a school-going child. After hearing the learned counsel for the parties and considering the fact that there appears to be some previous dispute between the parties, and that the petitioner is in custody since 10/12/2025. The petitioner is directed to be enlarged on bail with a condition that the petitioner shall not disturb the victim or his family member in any manner whatsoever.
Item 24, DA 2796 of 2026.
Because when the appeal order it has surfaced that the injuries were not sufficient to cause murder of the victim.
Where is FSL report?
There is no FSL report.
Counsel for the state.
Yes, ma'am.
Counsel for the state is directed to file counter affidavit in this case and also produce a copy of the FSL report
As well as the
in sealed cover along with post-mortem report. Office is directed to call for the case diary कोर्ट में है केस डायरी?
I don't have any case study.
Since when are you in custody? 18?
10.
Case diary, the counsel for the state, the office is directed to call for the case diary from the consent. Post on 4th May.
But doctor affidavit is also.
बहुत ज़्यादा हो जाएगा 30 तारीख को 30 FSL आप लेके आइए.
Item 25, DA.27.97 of 2026.
Earlier the bill was withdrawn, the case change is the order.
Simpliciter withdrawn.
I have received the case diary, postmortem report is I have. After the same case is
Post this case tomorrow. Case diary dे दें. The counsel for the state submits case diary to the court. इसमें सब है ना?
हाँ postmortem report.
Item 26, DA.27.98 of 2026.
Yes, petitioner.
First time listed. On 18/2/25, the informant received an information that the body of the daughter has been found in.
The CDR report was found around you. As per CDR report, you were found at the place of occurrence during the relevant time.
But the lordship, the FIR is lost on the basis of suspicion.
That's right. You are the name accused in that suspicion in the FIR, and in the CDR report you are found with the victim. What else is required at this stage?
No witnesses are there, nothing has been recovered, and he is the father, is the only parent of 3 minor children. That is the situation. And there has been dispute between husband and wife, and the
You are the husband?
Yes, Lordship. He is the husband, and the wife died, and his mother-in-law was this
And she has been living away from her husband in her matrimonial home for last 6 years.
Yes, yes.
And he used to come and threaten her that he will kill her.
Yes, that allegation is there.
Heard the learned counsel appearing on behalf of the parties. The counsel for the petitioner submits that the petitioner is not named in the FIR and there is no eyewitness to the occurrence. The petitioner is the husband and has 3 children. It is alleged that due to illicit relationship of the petitioner with another lady, he used to assault the victim, and victim was living with her parents for last 6 years, and the petitioner used to threaten the victim that he would kill her. Counsel for the state has opposed the prayer and has submitted that there is direct allegation against the petitioner, and as per the accused order itself, the tower location of the accused was found at the place and time of occurrence. After hearing the learned counsel for the parties and considering the fact that there is direct allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail. Is rejected.
Item 27, DA.2803 of 2026.
Yes. Just under section 103, subsection 1 of the analysis. along with the 3 and 5. Allegation is wife of one Chotelal Bean. She was sleeping inside the house and the Chotelal Bean was sleeping outside the house. In the night, the husband Chotelal Bean wake up and he informed the other villagers that somebody has killed her wife. It has been alleged against the husband that earlier he also tried to kill his wife. Subsequently, at the place of occurrence, one mobile phone was found and one cab was found. And on that basis, this petitioner has been made active in this case. Whereas there is no evidence that he was ever seen.
How your phone was there?
That is during the course of investigation, as per my information is concerned, the prosecution has not been able to prove this phone belongs to the petitioner. The IMI number as well as the SIM number. From that, the prosecution has not given the report of the
Your murder weapon has been recovered upon your.
That the says so far as the Chandi is concerned. But the postmortem report says the deceased has sustained injury caused by heart influence. That is the specific government I have taken in the decision.
The weapon has been sent for FSM. Counsel for the state is identified by counter affidavit and produce the case diary. Case diary तो कोर्ट में आ गया हूँ. Let the case diary be called for from the concerned court. Particularly, the counsel for the petitioner has submitted that the petitioner has been made accused on the basis of mobile and the SIM recovered from the place of occurrence, but there is no material during investigation to link the petitioner with the mobile phone or the SIM.
Certainly, nobody will left the mobile and
गलती से भी ठीक है. Post on 30th.
Item 28, DA.08.04 of 2026.
5 person committed deputy and murder. Amongst them, my lord, one of them was my brother-in-law, Salam. And my lord, charge sheet was submitted amongst 5 of them. And in the charge sheet, my lord, it came that my brother-in-law has confessed that he took a car from me, which belongs to me. This is the allegation. Then, my lord, I moved and disciplinary bail wherein I was directed to surrender and cooperate with the investigation for custodial interrogation. Now, my lord, I have filed bail, my lord, after submission of charge sheet. Since the police paper was submitted to me, I have annexed this specific paragraph 54 at page number 2, page number 26, which will make the case entirely clear, my lord, that I am not involved in this case. My brother-in-law is involved. Just because he took a car from me. Page number 26, my lord.
पढ़िए.
इस कांड
ये क्या पुलिस पेपर का पार्ट?
Yes.
बताइए.
इस कांड की तकनीकी शाखा के माध्यम से आप प्राथमिक अभियुक्त मोहम्मद नसीम करीब 30 वर्ष सच एंड सच जिला रांची का प्राप्त मोबाइल नंबर 50 सच एंड सच एंड 82 सच एंड सच का सीडीआर एवं टावर लोकेशन प्राप्त हुआ. सीडीआर एवं टावर लोकेशन का अवलोकन में पश्चात की ज्ञात हुआ कि मोहम्मद नसीम के मोबाइल नंबर सच एंड सच पर दिनांक 28/5/2024 को समय 17:38 बजे कॉल आया. 123 सेकंड बात हुआ. मतलब जो प्राथमिक अभियुक्त मोहम्मद नसीम के रिश्ते में आरिफ नैयर साला लगते हैं एवं उक्त मोबाइल नंबर सच एंड सच शकील नैयर सच एंड सच के नाम से है एवं उक्त नंबर को शकील नैयर के पुत्र आरिफ नैयर के द्वारा उपयोग किया जा रहा था. यह मोबाइल नंबर सच एंड सच के साथ आपातमिक अभियुक्त आरिफ नैयर के द्वारा घटना स्थल पर रहकर कांड को अंजाम दिया गया एवं आप प्राथमिक अभियुक्त मोहम्मद नसीम प्रेजेंट पिटिशनर सच एंड सच जिला सच एंड सच का उक्त दोनों नंबर सच एंड सच का सीरियल एवं टावर लोकेशन के से इनकी उपस्थिति घटना के दिन घटना स्थल पर ना ही अन्य अभियुक्त के संपर्क में थी। अतः इस कांड
क्या डकैती हो गया? क्या चीज डकैती हुआ?
Against them, my lord, this separate session trial is going. Some jewelries were looted, my lord.
Any recovery from you?
No, nothing. Only
Why trial is separated?
because I have, that is also there, my lord. I have surrendered by the order of this court, my lord. And before that, session trial was going on for the other 5 accused persons.
कब का केस है?
2024 का केस है।
कोई एंटीसीडेंट?
No, para 55 में। Next page, next paragraph.
302 भी लगा हुआ साथ में। 394, 302 also.
No, but 39, I just show.
302 is also there in this case.
Charge sheet has been submitted at 396. Dakati and murder. Yes, admitted. My lord, may come to one more thing, my lord. Page number 02/03, my lord. That is the internal page of the imping order. My bail was rejected just because I knew the anticipatory bail, my lord. Prayer for bail of the petitioner is vehemently opposed by the learned PP and it is submitted, though there is no allegation of direct involvement of the accused in the commission of murder of the deceased, namely Sushila Devi. Earlier anticipatory bail of the petitioner has been rejected by the Honorable High Court in the Apex Court of India, whereby this petitioner was directed to surrender before the trial.
क्या बोलना आपने?
Notice page number 30. It appears that the car used by them, accused Arif Nair at the time of commission of murder disease, had been given by this petitioner.
Admittedly.
बेटा को दे दिया ना?
जी?
बेटा को कार्ड दे दिया।
हाँ।
बेटा कार्ड लेके चला गया तो क्या करिए? एंटीसीडेंट भी नहीं है, कोई सर्कमस्टेंशियल एविडेंस नहीं है। कोई रिकवरी है? कोई टीआईटी है? टीआईटी हुआ आपका?
नहीं।
रिकवरी लिखे हैं कहीं?
कुछ नहीं, हाँ पूरा है, कुछ नहीं।
Or the learned counsel is appearing on behalf of the parties. The counsel for the petitioner submits that the petitioner has been made accused in this case only because his car was allegedly used in the commission of offence. He has submitted that his son is also a co-accused in this case.
No, brother-in-law.
His brother-in-law is also a co-accused in this case. He submits that the petitioner has no criminal antecedent and there is neither any recovery from the petitioner nor any TIP has been conducted. The learned counsel for the state has opposed the prayer and has referred to the impugn order by submitting that the car of the petitioner was alleged to have been used for commission of offence. And charge sheet has been submitted under section 396 of IPC.
396, 412, 448, 436, 427, 120.
412 किसके पास है?
Dishonestly received.
Dishonestly, that is not my allegation.
आपसे तो एक नहीं ना हुआ है रिकवरी?
नहीं.
After hearing the learned counsel for the parties and considering the submission that the only material which connects the petitioner is the alleged use of his car, and there has been neither any TIP nor any recovery from the possession of the petitioner. The petitioner is directed to be enlarged on bail.
Item 29, BA 2805 of 2026.
कोई victim नहीं है, कोई illegal transaction नहीं है।
वो विक्टिम भी नहीं है,
Criminal intoxicated है।
विक्टिम नहीं है।
नहीं, हम लिख रहे हैं paragraph 7।
आप काउंटरफाई कर दीजिए. Counsel for the state is direct. Counsel for the petitioner submits that in the present case no victim has come forward so far. Counsel for and has no criminal antecedent. Counsel for the state is directed to file counter affidavit along with criminal antecedent report of the petitioner and produce the case diary and submit it before this court 2 days prior to the next date. Post on 30th.
Under heading for admission, item 32, BA 1114 of 2025.
Counsel for the petitioner filing supplementary affidavit before this court.
It's a deposition of the doctor.
There was a direction.
Yes, there was a direction filed yesterday or yesterday.
हम तो कभी डायरेक्शन के सिचुएशन देते नहीं. Did I direct?
हाँ, डायरेक्शन
लिबर्टी है. Why should I direct you to do anything? Yes, tell me.
Yes, sir. The entire case is now 304B. Petitioner happens to be the husband, my lord, and the cause of death is not certain. Charge has been framed and one witness was examined, my lord.
Petitioner is the husband. Where was the body found?
Body was found in the house of the informant. Near the house, there is an allegation that I have kept the body in the house of the informant, near the house of the informant, and left the place of occurrence.
Just a moment. शादी कब हुई?
शादी 10 साल पहले.
Read the FIR.
संजय निवेदन है कि मैं रामकृष्ण यादव लेडी का रहने वाला हूँ. मैं अपनी पुत्री अनु देवी की शादी करीब 10 वर्ष पूर्व प्रभास यादव प्रतिष्ठा पिता सचिन सच के साथ रीति रिवाज हुई थी. शादी के समय में अपने सामर्थ्य के अनुसार दहेज दिया था और उनके बावजूद शादी के 1 वर्ष बाद से ही मेरी पुत्री अनु देवी के ससुराल वाले पति सास देवर ससुर पिता ससुर दहेज के लिए तंग तवा मारपीट करने लगे. इस संबंध में मुझे जानकारी मिली तो मिलने पर मैंने इस कई बार सामाजिक स्तर पर बैठक कर मामला निपटाने का प्रयास करते रहा और ससुराल वाले बराबर मारपीट करते थे. इसी दौरान मेरी पुत्री अनु देवी को 3 बच्चे हैं. कल दिनांक 19/5/2025 को मेरी पुत्री अनु देवी को उसके
FSL रिपोर्ट कहाँ है आपका?
आया. There's no poison found.
Poison है? मार्क करके दीजिए तो पेंसिल से.
लास्ट could not be.
नहीं है ना?
PW from the doctor, madam.
Cause of death also could not be ascertained.
Could not be ascertained. and there's no anti-mortem injuries.
Heard the learned counsel appearing on behalf of the parties. Counsel for the petition submits that he is in custody since 25/2025. He has further submitted that as per the postmortem report and the evidence of the doctor, the cause of death could be ascertained only upon the report by FSL, and there was no antemortem injuries found on the dead body. He submits that. As per the FSL report also, no sign of poisoning has been found. He further submits that the marriage was for last 10 years and 3 children were also born out of wedlock. It is alleged in the FIR that the petitioner had left the victim immediately before her death outside the house of the informant. The learned counsel for the state has opposed the prayer. However, the aforesaid submissions are not in dispute. कोई गलत बोले हैं ये?
नहीं.
After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, the petitioner is directed to the enlarged on this.
Item 30 DA.28.06 of 2026. ठीक लगाया हुआ
Only this case, or there are other cases also? There is one 6 तारीख को एक केस था 2728, इसमें क्या किया? कब का डेट है? 2728 कल केस था. देखिए सर, counsel for the state is directed to file counter affidavit along with criminal antecedent report of the petitioner that this case with BA number 2728 of 26, which arises out of the same FIR, in which case the ID has already been called for, pose this case on the next date, 29th, along with BA number 2728 of 26.
Item 33 DA.07.04.2026 of 2026.
Now under section 52 and 61 BNS, the corresponding is 304.
You are the husband? Are you the husband?
I'm the husband.
How much was the date period of marriage?
Marriage was 21st of May 2021. And my date of occurrence is 25th of August 24.
24. Where was the body found?
In the house, matrimonial house. Cause of death as the medical report, expressive due to hanging. The FSL report was not being received till date. The allegation was in the first part of the FIR number. It was said that everybody, Procedural wale, demanded 5 lakhs of rupees. Thereafter it is said 2 lakhs 50,000 rupees was transferred to my account. husband's wife. They are not paying 2,50,000 more. Again, she was tortured. But the concluding part of the FIR is, if you are showing the concluding part, that is at page 22. The type copy is also there, but page number 22A, second page of the FIR. You also will find after 6 lines, कल दिनांक 25/8/2024 के समय करीब 11 बजे I'm sorry. Second page of the
Page number 22.
22. From the bottom, my lord.
22 is only one page. FIR is only one page.
You have made the type copy, second copy in the type.
Okay. Alright.
बहुत छोटा लिखा हुआ है.
हाँ, कोई बात.
From the word 1, 2, 3, 4, 5, 6, 9. कल दिनांक 25/8/2024.
Yes.
उस समय करीब 11 बजे दिन में मेरी बेटी के साथ मेरी फोन पर बातचीत हुई और बेटी के द्वारा बोला गया कि सास ससुर दोनों देवर के द्वारा कई दिन से बहुत प्रताड़ित किया जा रहा है और वे लोग अबॉर्शन कराने को कह रहे थे। रांची स्थित घर में बनवाने के लिए, घर के लिए पैसा लाने के लिए कह रहे थे और मेरे द्वारा रांची आकर समझाने बुझाने के बाद भी ये बात कहकर मेरी बेटी को फिर से सांत्वना दिया गया। कल दिनांक 25/8 समय करीब 1:30 बजे मुझे मेरा दामाद वर्मा द्वारा फोन कर बोला गया कि आपकी बेटी फांसी लगाकर मर गई है और करीब 15 मिनट. This is one of the case. Now, during investigation from our side, we have given that he was in Godda. He is a carpenter. And he immediately rushed up to Ranchi after hearing this, and it was communicated by me to the successor. And except here at page 26, that I was in Godda. And the postmortem report was doesn't wait, but forensic, that is FSL report was not available. And apart from ligature mark, there is no antemortem litigation.
You can use a train journey. Train journey ticket. This one.
Yeah, diary may be
This is died within 3 years of marriage. And additional dowry was demanded. And paragraph 10, 11, 17 and 18 of the case diary, all of the cases were supported.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner is the husband who was married to the victim on 21/5/21, and the earliest date of and the date of death of the victim in her matrimonial house, that is his wife, is 25/8/2024. He has further submitted that the cause of death was asphyxia due to hanging, and at the relevant point of time, the petitioner was in Godda, for which he has referred to Annexure 3, which is the train ticket. The learned counsel has submitted that the petitioner has been made accused in this case only because he is the husband.
That's
The counsel for the state has opposed the prayer and has submitted that there is direct allegation of demand of dowry and torture of the victim, and the demand of rupees 5 lakhs was made and rupees 2,50,000 was received in the account of the petitioner. We submit that the allegations are very serious and the victim died within a period of 3 months, 3 years,
3 years,
less than a period of 3 years from the date of marriage. out of torture and demand of dowry. After hearing the learned counsel for the parties and considering the direct allegation of demand and torture, and also the petitioner had taken money in his own account amounting to rupees 2,50,000, which is alleged to be the payment on account of demand of dowry, and it is alleged that remaining 2,50,000 was further demanded. This court is not inclined to endorse the petition on bail.
One submission. The trial has started. Out of 5 witnesses, 3 has already been examined.
At this, the learned counsel for the petition has submitted that the trial has commenced. Out of 5 witnesses, 3 witnesses have already been examined. He submits that the trial may be expedited. Counsel for the state is directed to ensure that the witnesses are promptly produced before the court. Counsel for the state is directed to communicate this order to the SP of the concerned district and also to the director of prosecution to ensure compliance.
Passover case item 11 from the supplementary list DA 521 of 2026.
Yes. Ready for your DNA test?
My
Paternity test.
So you received this slide just saw one thing in the 18 also. Second last page.
Yes.
That is the 18 order.
Hmm.
Third last paragraph on page 60.
Yes.
That's all.
Yes. Second last paragraph.
Third last.
In paragraph 25 of the case study, it has been written that RU has advised that after delivery of the womb and after 6 months of the infant, DNA test could be done. So you are ready for it.
He is ready.
You are happy?
But still, my lord, he has made video without my knowledge. He is continuously pressurizing me to make a physical relationship.
Just a moment. वीडियो सीज हुआ है, उसका हो गया सब एग्जामिनेशन. फिर इस वीडियो का क्या वैल्यू है आपका? 65B का सर्टिफिकेशन हो गया? नहीं हुआ ना? यस. Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that petitioner has been falsely implicated in this case, and it is alleged in the FIR that petitioner had committed rape upon the victim in false pretext of marriage. It is also alleged that the petitioner had taken the victim to Gujarat, where they lived as husband and wife. And the victim became pregnant, but the petitioner refused to marry. It is also alleged that a video was prepared and the petitioner has been blackmailing the victim and has committed repeated rape. The counsel for the petitioner has submitted that as per the improved order itself, it has been mentioned that in paragraph 25 of the case diary, it has been written by the IO that the doctor had advised that after delivery of womb and after 6 months of the infant, DNA test will be conducted. the learned counsel submits on instructions that the petition is ready for paternity test. The child has been born on no date. The learned counsel for the FIR कब का है?
नवंबर 2025 4 months back from today.
How much was the pregnancy? How much was the pregnancy? How many months? The learned counsel for the opposite party has
At the time of 4 months.
4 months at the time of occurrence. तो भी तो चाइल्ड बर्थ के तो 6 महीना बाद ही. And the learned counsel for the state and the informant have opposed the prayer for bail and have submitted that there is direct allegation against the petitioner. They have submitted that if the petitioner is ready for paternity test, he may renew the prayer for bail after the test. Right? They have also submitted that the petitioner may file an application before the court for the purposes of the paternity test. Okay? After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, this court is not inclined to enlarge the petitioner on bail at this stage. However, upon conduct of paternity test, the petitioner may renew his prayer for bail. You get your paternity test now. पासओवर बाद इनका पासओवर हो गया, इनका कल रेगुलर केस हो गया. सर पासओवर आप जिनका पासओवर नहीं टेकअप होगा तो कल हो जाएगा, लेकिन जिनका एक बार कॉल होगी पासओवर, आपका तो कल भी पासओवर हुआ था.
वो स्टेट टाइम भी है.
कोई बात नहीं, देखते हैं थोड़ा वेट.
From daily list, item 34, DT.07.04.2026.
Three practicing the 4 villages. 2 FIRs were lodged for the allegation of assault and 109 attempted murder. Some injuries were sustained by both the parties.
Where is the FIR? Read the FIR please.
Page number 16.
पढ़िए.
निवेदन पूर्वक कहना है कि मैं माला देवी उम्र 7 वर्ष पति गोपाल यादव ग्राम भोजपुरी थाना देवरी जिला गिरिडीह की रहने वाली हूँ. नाम 4/10/25 को समय करीब 7 बजे सुबह हम सब परिवार अपने घर में थे. इस समय पूर्व विवाद को लेकर राजेश यादव, पिता सरस्वती दिलीप यादव, संजय यादव, पारू यादव, परमिला देवी, दूरी देवी, मुनिका देवी, दिलीप यादव का परिवार सभी साथी भोजपुरी थाना देवरी जिला गिरिडीह अचानक गाली गलौज देते हुए. राजेश यादव के हाथ में तलवार था. उसी तलवार से मेरा बेटा महावीर यादव को जान मारने के लिए तलवार से प्रहार किया, जिससे मेरा बेटा गंभीर रूप से जख्मी हो गया. दिलीप यादव का फर्स्ट पिटिशन. दिलीप यादव के हाथ में कुल्हाड़ी था. उसी कुल्हाड़ी से मेरी बेटी रीना देवी को सिर पर वार किया. जब मेरी बेटी रीना देवी गिर गई, ऊपर से चढ़कर किया, जिसमें रीना देवी भी गंभीर. पारू यादव का सेकंड पिटिशन. लाठी लेकर आया था, जिसमें गोपाल यादव को लाठी से मारकर गंभीर रूप से घायल किया. संजय यादव थर्ड पिटिशन में संजय यादव के हाथ में भी लाठी था, जिससे उसने किशोर यादव मेरा बेटा को लाठी से मारकर घायल कर दिया। दिलीप यादव की पत्नी भी टांगे लेकर आई थी, जिसने मेरी बहू रिंकी देवी को जान से मारने के लिए प्रहार किया, जिससे रिंकी देवी का हाथ में भारी गंभीर चोट है। इस क्रम में मेरे गला में सोना का चेन था जो दिलीप
डायरेक्ट एलिगेशन है, इंजरी रिपोर्ट भी होगा।
Yes, my lord.
Previous injury
Second
है।
petitioner and third petitioner, my lord. There is an allegation they were having lathi in their hand. I have also filed a supplementary affidavit, my lord. There is another FIR by the wife of the petitioner number 3.
पारो यादव के हाथ में लाठी था, ठीक
Yes,
है?
ma'am.
और
संजय यादव के हाथ में लाठी था।
संजय यादव
पारो यादव के नीचे।
पारो यादव के नीचे लाठी से मारकर घायल कर दिया। बेटा का क्या नाम है उसका? उसका इंजरी रिपोर्ट है, बताइए। Previous injury on right hand. कितना दिन से कस्टडी में है? कोई एंटीसीडेंट है?
In custody since 5/10
2025
around 6 months they are in custody.
Any antecedent? Any antecedent? आप नहीं लिखे, आपको नहीं पता?
Yes, madam. R12. That is stated. Petitioners have got 2 criminal antecedents.
All the petitioners.
Yeah, petitioners.
क्या बोलना है आपको?
डायरेक्ट एलिगेशन क्रिमिनल इंसिडेंट अपारियों पूर्व में झगड़ा चल रहा है उसमें
Heard the learned counsel appearing on behalf of the parties. The counsel for the parties, the counsel for the petitioner submits that the petitioner has been falsely implicated in this case and there is previous enmity between the parties. The learned counsel has further submitted that so far as petition number 2 and 3 are concerned, they were holding lathi in their hand. The counsel for the state has opposed the prayer and has submitted that as per the bail petition itself, the petitioners have 2 criminal antecedents and there is direct allegation against the petitioners who had joined together to assault, causing grievous injuries to number of persons, including female members of the family. After hearing the learned counsel for the parties and considering the direct allegations made against the petitioner and number of persons have suffered grievous injury, this court is not inclined to enlarge the petitioners on bail, hence rejected. आप अपना query से कीजिए, informative.
Item 35, DA1093 of 2026.
Yesterday only, I and Yogalika were responding to this case. counter
Your counter affidavit. Informant is also required to file a counter affidavit.
Yes, in this case, there are certain relevant documents which are needed to be
But you cannot file anything which is beyond the records, isn't it? The case diary has come. Counter affidavit has been filed, supplementary affidavit of the petitioners.
In this case, the last officer report was filed, but only case diary has not been filed. Report from the last case diary has not been filed.
What was the report? Why did you call for the report?
Report you also in this case on last occasion my bail was rejected in the month of August 2025, considering that out of 22 witnesses, 10 prosecution witnesses were examined. And the report has been called for that why in 6, 7, 8 months the other witnesses have not been examined.
12 witnesses have already been
Yes, earlier 10. In 8 months the lordship only 2. And 8. As of now 13. Probably one more has been examined. One more has been examined. My case is that it remained in custody for more than 1 year, 8 months. And in this case, charge has been claimed 2025. Last, in the month of 7/8/2025, my case was rejected, considering that 10 witnesses out of 22 have been examined. In other 8 months, only 2 witnesses have been examined.
What is the allegation against?
Allegation: the victim has committed suicide at Ranchi. This petitioner, though he is the husband, he was posted at Saharanpur, Uttar Pradesh. After that, he came to Ranchi. It has also come in the case that he was not present at the place of offence. Allegation of demand against the entire family member, not against the petitioner, against the entire family member. There was case and counter case. The cause of death, the other grounds have also been taken that the victim has committed suicide not because of this petitioner, rather because of her parents, because they have tortured the victim. For that reason, he has committed suicide. One case has also been filed as against the father-in-law. And victim has committed suicide. Doctor has also been examined in this case. He has stated
The case and counter case are very important to counter file करने की जरूरत है.
it should put a date in it.
How much time do you need? The learned counsel for the state. The learned counsel for the informant appears and submits that. And pays for 1 week time to file a counter affidavit. Counsel for the state is directed to produce the case diary. आप कर देंगे produce? हाँ. Post on 30th April. The case diary we submitted to this court on 28th.
Item 36, DA 1107 of 2026.
The counter has come during course of their counter rating.
Case of cyber crime. There's one mobile phone with one SIM in the mobile and one SIM in the back of the mobile has been recovered from the possession of the petitioner.
One phone and?
One phone with SIM and thereafter one SIM from the back of the mobile.
One phone, one SIM, plus one additional SIM.
Right.
All in your name?
Yes, one SIM is not in my name.
Only one SIM is not in your name.
And several co-abuse persons in that language. All the co-abuse persons.
How many victims are there?
There are 2 victims.
Amount कितना involved? 2 victims से कितना amount involved?
Around 5,000 and in another around that's around 5,000.
Any antecedent?
No antecedent.
Custody?
18/11/2020.
Bail orders? हाँ बताइए.
It's one CVG name of other civil investigation. 2 victims have been tested out who have given a statement that they have been cheated. उसकी स्कीम है, उसमें ऑल अराउंड इंडिया में 5,502 कंप्लेन है सर।
Five, how many SIMs? In these two SIMs, how many complaints are there?
सारे accused का शो किया हुआ है एक साथ।
सारे accused का ना, लेकिन ऑर्गेनाइज क्राइम तो नहीं बनता, सारा प्रॉब्लम आपका वहीं पर है। इन लोगों का लिंक दिखाइए, साइबर क्राइम में साइबर में ही दिखेगा ना लिंक। Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 18/11/2025 and has no criminal antecedent. One phone with SIM and one additional SIM has been recovered, and out of them, one SIM does not stand in the name of the petitioner. He has also submitted that, he has also submitted that no case of organized crime is made out against the petitioner, as no cyber link has been found with other co-accused persons. The learned counsel for the state has opposed the prayer. He has further submitted that number of co-accused persons have been enlarged on bail. ये है सारा details he has given, who are similarly situated as that of the petitioner. The learned counsel for the state has opposed the prayer and has submitted that 2 victims have been identified and they have supported the case against the petitioner. After hearing the learned counsel for the parties and considering the fact that the petitioner is in custody since 18/11/25, having no criminal antecedent, and similarly situated accused persons have been enlarged on bail, the petitioner is directed to be enlarged on bail.
Item 37, DA.07.04.2026 of 2026, along with item 38.
उसमें था counter affidavit is being filed in the course of hearing which is taken on record. Yes.
One C, there is one victim, but the call made by the SIM number that has not been recovered from the position of the petitioner, and that several similarly situated, no criminal antecedent, several similarly situated co-accused granted bail by this honorable court.
Counter में क्या लिखे हैं?
Yes, in Ibrar answering this directive cases. Ibrar answering this two crime rates. One victim she has given statement, he has given statement that cyber fraud of rupees 1,71,000 and not has been detected. And recovery of the SIM is in the name of some other person.
Any antecedent?
No.
Antecedent is not there.
Custody.
Custody 24/11/2025.
There are 2 petitioners.
Other case, there is another
एक
petitioner.
पहले बताइए कौन सा?
Ibrar.
इब्रार अंसारी। हाँ, इनका बताइए।
There is no criminal, one mobile, one SIM.
One mobile, one SIM.
Custody 24/11.
24/11/25.
No criminal.
No antecedent.
Yes. The call has been. There is one victim who has been made call by mobile number 7386. 892743, but the same has not been recovered from the position. The mobile SIM number recovered is 9635451299. That is different. And in the next case,
एक सेकंड पहले इसका DA number 1118 of 2026.
the charge sheet has not been submitted under organized crime. It is not under.
Heard the learned counsel appearing on behalf of the parties. The counsel for the petitioner submits that the petitioner is in custody since 24/11/25, having no criminal antecedent. He further submits that one mobile, one SIM has been recovered from the possession of the petitioner, and it appears that one victim has come forward, but there is mismatch in connection with the SIM number and the mobile number. He has further submitted that numerous persons have been enlarged on bail by coordinate benches of this court. Counsel for the state has opposed the prayer and has submitted that that one victim has been defrauded for an amount of rupees 1 lakh.
1,71,000.
1,71,000 and all. 1,71,000 and all. After hearing the learned counsel for the parties and considering the fact that similarly situated co-accused persons have been enlarged on bail by coordinate benches and the petitioner has no criminal antecedent and is in custody since 24/11/2025, the petitioner is directed to be enlarged on bail. दूसरा
दूसरा मैं वन मोबाइल 3 सिम, 2 सिम मेरे ही नाम से है, मेरा और मेरे भाई का सिम है, और एक थर्ड सिम है जो कि कहते हैं उसे नो क्रिमिनल एक्सीडेंट,
one mobile, 2 SIMs, no criminal antecedent.
No criminal antecedent.
Custody.
Custody 24/11.
24/11.
And there is one victim of 11.
One victim.
11,000.
Or the learned counsel is appealing on behalf of the
That is
parties.
also mismatch. I am here number and mismatch.
Same order.
Same.
Same FIR.
Same FIR.
Same FIR है, same order है, लेकिन material चीजें दिख लीजिए.
Material recovery.
24/11/25 से custody है. There is no criminal antecedent. One mobile and 2 SIMs.
3 SIMs.
One mobile and 3 SIMs. One victim defrauded for 11,000 rupees. Similarly situated have been enlarged.
काउंटर एफिडेविट टेकन ऑन रिकॉर्ड वाला होगा।
हाँ, इसमें तो काउंटर नहीं दिए ना, पहले से दिया हुआ है। हाँ, दे दीजिए काउंटर।
38.
Item 39 DA.07.04.2026 of 2026.
Yes.
The issue relates to attempt to entice away the victim for the purpose of prostitution. This is the allegation.
Age of victim?
16 plus. The first information report matters. I'm guessing the first information.
Yes, please read that.
Age 12.
Yes, yes.
Neither man whom such and such, the state of such and such, में thus इनको मेरी बेटी सच एंड सच उनको 16 वर्ष द्वारा बताया गया है कि मोबाइल नंबर सच एंड सच से मेरी बेटी के मोबाइल नंबर सच एंड सच पर बार-बार फोन करके मेरी बेटी को वो बताई मैं डाल्टनगंज से बोल रही हूँ मैं तुमको जानती हूँ बोलते हुए मेरी बेटी को बोले कि तुम हम लोग के पास आ जाओ तुमको अच्छा खासा पैसा मिलेगा एक रात का सच सच मिलेगा एंजॉय करना इस बात को मैं ASLES के मनी के उनको बताई इसके बाद मैं लोग डाल्टनगंज से मेरी बेटी को लेने के लिए आज दिनांक सच सच को वाहन नंबर सच से करीब 2 बजे चैनपुर दुर्गा मंदिर के सामने आए थे जिस पर चालक सहित 4 व्यक्ति इस बात की सूचना मैं पूर्व में भी ASLES के सचिन को दी थी इसके बाद ALES के ग्रुप के सचिन के द्वारा पकड़ा गया पश्चात टेलीफोन थाना का सूचना against my the allegation is that I happens to be driver of vehicle number DT.03.80.9491 DT.03.80.9491 Earlier case diary was called for and from some paragraphs of the case diary it appears that the petitioner never talked with the victim. That allegation has been attributed to other persons.
Any antecedent?
No antecedent. That has come at paragraph 115 of the case diary.
क्या बोलना है?
Only an attempt.
No antecedent also, but they have enticed away girl for taking her.
They had come.
But they could not.
No.
They did not succeed.
Only attempt was. They had come.
Heard the learned counsel appearing on behalf of the parties, the counsel for the petitioner submits that the petitioner has been made accused in this case primarily because of the reason that he was the driver of the vehicle used for the commission of the alleged offence. He submits that there is an allegation that the the accused persons made attempt to entice the minor girl for prostitution. He submits that all the persons were apprehended by virtue of trap laid by the police. The petitioner has no criminal antecedent. He is in custody since?
He is in custody. Date of
22/12/25. इसी तारीख से होंगे ना? Is 22/12/2025. The counsel for the state has opposed the prayer. However, the aforesaid submissions are not in dispute. After hearing the learned counsel for the parties and considering the fact that the petitioner considering the aforesaid facts and circumstances and that the petitioner is the driver of the alleged vehicle and the custody since 22/12/25, having no criminal antecedent, the petitioner is subject to be indicted.
one is arising of the sale of non-human beings.
Sorry?
Another matter arising out of the same FIR is also in this.
आज के लिस्ट में
Thank you.
दो जने तो ड्राइवर नहीं हो जाएंगे ना? कौन कौन है? देखते हैं। अब बाकी केसेस का क्या करें? आपका केस तो पास ओवर भी है तो।
I pass out the state council is present here if possible.
ये 43 नहीं 43 बन जाएगा। हम लोग का कितना केस बच गया? 16 केस बच गया ना? पास ओवर 16 केसेस हैं।
दो केस पास। नंबर 16.
अच्छा नंबर 16
This matter was heard yesterday. The landlady to whom the case was ordered, he was not.
बताइए।
Yes. The case was registered under section 109. Main section is 109 of the Penal Act. I would like to place the written report, Honorable Sir.
So we have seen it.
Yes, sir.
That is.
As per the first information report, the informant is not an eyewitness to the offence. He came to know about the offence from Udra, whose husband of the deceased. He says his statement has
He is also not he is not the FIR, not the eyewitness.
He is also not the eyewitness.
He is also not the eyewitness.
Subsequently, the mother of the petitioner was not project, but she had coming from outside and she had seen this petitioner flee.
This petitioner, his mother.
Mother. I am also the state of that. I am also at the sides there.
So your mother had seen?
I was in the house.
Okay.
I have seen by my mother, but natural. But with regard to assault against me, the allegation is I gave a rod blow on the head. That rod was also found lying there without having any blood. The case of the prosecution is that I assaulted with blood. Yes, or not. But the postmortem report completely belies the case of the prosecution.
Bullet injury.
Bullet injury was found. There is no such allegation in the first information report. Nobody had said anything. Had to using bullet by me or firing. Nobody had heard.
In your confession statement, it has come that you had thrown the
in the pond.
In the pond.
There is no recovery.
No, there is a reason. They say that it is not possible to recover from the pond.
He has broken the. But what is the case? Case is that assault has been done by piece of law. This is not the case that I used. Confession, anything can be written by the police officer. It's not the case confession under section 164. Police says that he confessed, but there is no recovery. There are certain procedures to record the confession.
लाठी भी इनको लाठी का तुरंत
वो भी नहीं मिला,
वो भी इनके कन्फेशनल स्टेटमेंट में नहीं मिला,
स्पॉट पे मिला,
स्पॉट पे मिला है, उसके बाद इनका कन्फेशन रिकॉर्ड हुआ है।
4 to 5 days.
बाकी चार्जशीट हो चुका है,
सब हो चुका, सब कुछ हो चुका।
कब से कस्टडी में?
कस्टडी में है 2nd of November 25.
Heard the learned counsel's opinion on behalf of the parties. The counsel for the petitioner submit that neither the informant of the case nor the person from whom the informant gathered information about the alleged occurrence committed by the petitioner are eyewitness to the occurrence. He submits that the mother is said to have seen the petitioner with a stick and running away from the place of offence. And as per the FIR, the victim died on account of assault by
No, that is not the case. She was admitted in the hospital. She
in
was
an injured condition.
Injured condition. She was hospitalized there, and after 7 days she died. And the doctor says the injury has been caused just 6 to 18 hours prior to her death.
Okay.
This is also the case. So the occurrence had taken place about a week ago.
देवर ने मेरी बहन को मार पीट कर गंभीर रूप से जख्मी कर दिया। As per the FIR, the sister of the informant was assaulted by the petitioner.
On 30th, and she died on 5th.
Yes. On 30th, and she ultimately died on 5th. The learned counsel submits that there is no allegation of any bullet injury or any assault, any firing in the FIR. However, the post-mortem report reveals that the victim died out of bullet injuries. The learned counsel submits that the petitioner has been falsely implicated in this case.
Marriage was 15 years prior. She had been living.
The learned counsel for the state has opposed the prayer. However, it is not in dispute that the victim died on account of bullet injury. After hearing the learned counsel for the parties and considering the aforesaid submissions, and there has been no recovery of any firearm from the possession of the petitioner, and there is no eyewitness to the occurrence, the petitioner is directed to be enlarged on bail. These remaining cases will come up tomorrow, and there is one Passover matter.
That is also not in that case, not co-accused is also listed.
कल ही हो जाएगा। कोई भी उसका केस नंबर क्या है?
एक केस तो आज ही था, 2 को आज लगा, 1 कल लगा है, that is
ठीक है, कल देखते हैं।
yes, that is DT.07.04.2026 of 2026. It is listed tomorrow.
Okay. Post this case along with BA number 791 of
2026.
2026.
And one is today is listed another at serial 44 1510.
And with BA number 1510
of 2026.
of 26. Serial number कौन सा है?
44.
40.
All these 3 केसेस
एक 44 है, दूसरा कौन सा सीरियल नंबर है?
आज जो पासवर्ड सीरियल 15
सीरियल 15 है
और एक कल है 791 सीरियल नंबर
ये सीरियल अच्छा 791 देखिए तो 791 का सीरियल नंबर और वो कल है ठीक है आज 15:44 में कॉमन ऑर्डर ड्रॉ कर देंगे टू बी लिस्टेड tomorrow and to be taken up along with BA number 791 of 26.